Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I'll be with you for the next 4 or so hours. Let's get our day started. Allegan County, Michigan. This is Judge Joseph Scoselis.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Bishop for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, and he does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
When or not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you're released from the Allegheny County Jail on a $500 personal recognizance bond. Bail will be continued in that amount. Condition of bail on this charge is that you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Case to be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your next court appearance. Next court appearance date and time will be sent to you by the clerk's office in the mail. So you are free to hang up the court proceeding this morning. Be expecting that in the mail, okay?
Okay, so that's all I've never had to do anything like this before, so that's all I got to do is just wait for my other booklet and then appear to that and.
Correct.
Okay. Thank you.
260.
You're all set.
260657 SM, People versus Emily Marie Brown. Here this morning for arraignment, charged through a citation issued by the Allegheny County Sheriff's Department on a charge of operating an uninsured motor vehicle. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. Brown for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. She's entering a plea of not guilty, and she does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
We'll enter a not guilty plea. Set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail at $1,000 personal recognizance. Condition of bail is that you not operate this 2010 Toyota until insurance is obtained for that vehicle. Case to be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the public defender's office will contact you and discuss your case with you at your next court appearance date. Your next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting that in the mail, okay?
Thank you, Your Honor.
About 260662 SM, People versus Damian Joseph Burr. Here this morning for arraignment, charged through a misdemeanor complaint issued by the Allegheny County Prosecutor's Office on a charge of stalking in a domestic relationship. Count 2 is a charge of malicious use of a telecommunications service in a domestic relationship. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Burr for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, and he does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
When or not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows bail is set at warrant authorization at $1,000 personal recognizance. Bail will be continued in that amount at this time. Case to be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at the date and time of your next court proceeding. Your next court proceeding date and time will be sent to you by the clerk's office in the mail. So you are free now to hang up from the court proceeding this morning. Be expecting your next court appearance date in the mail. Okay?
Okay, thank you, sir.
I have two files on Charles Richard Doden. These are files 260611 ST and a charge of operating outside of a restricted driver's license, and file 260610 ST, a charge of fleeing the scene of a property damage accident. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Doden for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering pleas of not guilty, and he does qualify for a court-appointed attorney. We would request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Each of these two criminal files will enter not guilty pleas. Set these for jury trials. Indicate you're requesting an attorney at public expense. And each file will set bail at $500 personal recognizance. Condition of bail is that you not operate a motor vehicle outside of the restricted driver's license issued to you by the Michigan Secretary of State's office. Both of your cases will be set for pretrial conferences with the prosecutor's office. Both will then be set for jury trials in this courtroom, District Courtroom A. The public defender's office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at the date and time of your pretrial conference. Pretrial conference date and time will be sent to you by the clerk's office in the mail, so you are free to hang up from the court proceeding this morning. Be expecting that in the mail. Okay?
Thanks, Your Honor.
254077 SM, People versus Macy Lee LaFountain. Here this morning for arraignment charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office and a charge of assault and battery. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. LaFountain for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. She is entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Under not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows bail will set a warrant authorization at $300 personal recognizance. Bail will be continued in that amount at this time. Condition of bail on this charge is you have no contact with Breer Carlisle Pride while the case is pending. Case will be set first for pre-trial conference with the prosecutor's office and then for jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will contact you and discuss your case with you at the date and time of your next court appearance. Next court appearance date will be sent to you by the clerk's office in the mail. So you are free to hang up the court proceeding this morning. Be expecting that in the mail. Okay?
Okay, thank you.
File 260687 SM, People versus Jeffrey Michael Larson. Here this morning for arraignment, charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office and a charge of domestic violence. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Larson for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, but does not qualify for a court-appointed attorney as his income exceeds the indigency requirements. We request that this matter be set for a pretrial and a jury trial, and we would also like to address bond at this time, Your Honor.
Go ahead regarding your bail request.
Thank you, Your Honor. We would request that bond be amended to allow Mr. Larson to leave the state as he lives out of state. Let me pull up. I believe it's Illinois, if I remember correctly, but I can get the actual state.
Still in Michigan at this time?
Correct.
Will enter a not guilty plea indicate your request for a public defender is being denied by the public defender's office. So with that, Mr. Larson, you have two options, either to hire your own attorney in this case or represent yourself. Do you intend to hire your own attorney or represent yourself?
I'll be hiring an attorney.
Okay, with that then, I will set this for a jury trial. Bail in this case was set at warrant authorization at $500 personal recognizance. This is a protective bond. We'll continue bail in that amount. I will amend the bail to indicate you may leave the state of Michigan while the case is pending. Your case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. At this point, court staff will mail to you the date and time of your next court appearance. If you do hire a lawyer, be sure to forward the date and time on to your attorney. With that, you are all set today. Be expecting your next court appearance date to be sent to you in the mail. Okay?
Thank you, sir. Appreciate it.
About 260459.
Good morning once again, everybody. TCF Live on a Monday. Good to have you here. I see up in my feeds at the moment, there's something going down at LaGuardia. Apparently an Air Canada plane collided with something, looks like on the runway or tarmac somewhere. The two pilots are dead and 41 have been taken to the hospital. So I'm going to try to get more info as to exactly what that was all about. But we do court here, so let's continue with that. Huron County, Michigan, this is Judge Prill.
24 FH, time and date set for arraignment. The defendant is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Rutkowski. Ms. Weisenbach, have you received a copy of the information? Have you and your client had the opportunity to review it? And do you waive the reading as well?
Yes.
Appears there's a plea agreement here, correct?
Yes.
Thank you. Sir, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Thank you. Mr. Rutkowski, would you please state the terms of the plea agreement on the record, sir?
Yes, Your Honor. Mr. Hewins would be pleading guilty to both counts, and that people agree not to bring any additional counts.
Ms. Weisenbach, is that your understanding of the plea offer?
Yes.
Mr. Hewins, is that your understanding as well, sir?
Yes, sir.
And you wish to accept this plea offer?
Yes, sir.
Are there any other terms to the plea offer that we've not covered on this record?
No, sir.
Ms. Weisenbach, do you agree?
I do.
And Mr. Rutkowski?
I agree, Your Honor.
Mr. Hewins, are you on any term of probation or parole?
No, sir.
Have you had sufficient time to speak to Ms. Weisenbach about this?
Yes, sir.
Do you need any additional time to speak with her?
No, sir.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No, sir.
You have a clear mind?
Yes, sir.
In the information, sir, you're charged with, that is in count 1, unlawful posting of a message. That is a felony carrying a maximum prison sentence of up to 2 years and or a fine of $5,000. Also indicates that you may have to reimburse the government for expense incurred in relation to the violation. In count 2, you are charged with a misdemeanor known as telecommunications service malicious use. Again, that is a misdemeanor carrying a maximum Huron County jail sentence of up to 6 months and or a fine of up to $1,000. You understand the charges, that is, and the maximum sentences that can be imposed.
Yes, sir.
Understanding that, then, Mr. Hewins, how do you plead to both on or about January 6, 2026 in the city of Harbor Beach, County of Huron?
Guilty, sir.
Is it because you are guilty, sir? Court is in receipt of an advice of rights form, has a signature on it, has the printed name of Cameron Hewins. Did you sign this document, sir?
Yes, sir.
Now, before signing it, did you read it over?
Yes,
Did you also go over it with Ms. Weisenbach?
sir.
Do you understand the rights contained on the form?
Yes, sir.
By pleading guilty, you're giving up those rights.
Yes, sir.
It means you will not have a trial of any kind nor have any opportunity, that is, to contest your guilt. And all that remains after today will be for you to be sentenced. If these pleas are accepted, you'll be giving up any claim that the pleas are the result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim that these pleas are not of your own free choice.
Yes, sir.
Other than the terms of the plea agreement as provided by Mr. Rutkowski, has anyone promised you anything such as leniency to get you to plead guilty?
No, sir.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence.
Yes, sir.
Does anyone promise the court would be easy on you?
No, sir.
Does anyone threaten you to enter these pleas?
No, sir.
These pleas are your own free choice. Financial obligations, court costs are due and payable at time of sentencing unless there's good cause shown. And that you're subject to a 20% late penalty for any unpaid court obligation due 56 days following your conviction and sentence. Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeals from the convictions and sentences pursuant to these pleas will be by application for leave to appeal and not by right. You understand all those rights? Yes. Any questions of Ms. Weisenbach? Ms. Weisenbach, do you wish to establish a factual basis?
Okay,
Please.
okay, so with regards to count one, this was on or about January 6th, 2026, that was this year, correct? And where were you at that, like, what town? Okay, is that in Huron County? And have you been drinking? And were you putting online, using the internet, some posts that were inappropriate and that would have caused Carrie and or Timothy Kaiser to feel harassed? Things to the effect of, these were comments on a Facebook post, would that be correct? So they were for everyone in your friends group to see and friends group of these individuals, is that correct? So that's a lot of people. It's not necessarily public, but it's out there, right? Okay. Things to, not to the effect that you would kill an individual, but insults could be construed as racial slurs if they had actually been applicable, correct? Going crazy and just making profanity comments, is that correct? Okay, so with regards to count two, you were using your cell phone to do this? So a telecommunication device, and this was malicious use of that, and it was the same, like offensive language that would harass and disturb Carrie and or Timothy Kaiser, is that correct? So we have established a factual basis, Your Honor.
Mr. Rakowski, any objection to the factual basis?
No, Your Honor.
You aware of any promises, threats, or inducements for these pleas other than what's been disclosed?
No, Your Honor.
Ms. Weisenbach.
Agreed.
Has the court complied with the court rule concerning pleas, Mr. Rakowski?
It has, Your Honor.
Ms. Weisenbach.
Yes.
And Mr. Hewens, there's no agreement made by this court concerning the pleas and what the sentences will be. Is that accurate? Yes. Ms. Weisenbach, do you agree?
Yes.
Mr. Rakowski.
Yes, Your Honor.
Court will accept the pleas. They're done freely. They're voluntary. They're understanding and accurate. There's a sufficient factual basis. We'll accept the pleas and schedule sentencing. Thank you, Ms. Weisenbach.
Any chance we could do it May 11th? I think that's the holiday. That's the holiday.
Week after that,
We'd be in June. Is that okay?
Yes.
What date is that?
June 1st.
June 1? We'll schedule sentencing June 1, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided to both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the court no later than 7 days from sentencing. Mr. Hewens must be in the courtroom at time of sentencing. If there's any supporting documentation, must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set at $3,500 personal recognizance. Mr. Rakowski, any objection to continuing bond?
No objection.
Thank you, Ms. Weisenbach. Comment relative to the bond.
Ask court to continue.
And it shall. Bond will continue as previously said. Mr. Hewens, you'll be meeting with the probation agent to schedule an appointment. Make sure you follow through with that, and we will then see you then on that June date. That'll be all. Right.
Thank you, Your Honor.
You're welcome.
Okay, friends, let's stay in Michigan, but we'll go say good morning to Judge McNally.
0528 for non-payment of rent. Did you know that was pending?
Right to the podium, sir. Right next to me.
Did you know that was pending?
I don't think that there's a pending case on the non-payment.
Yes, there is. And
There was a judgment going on, wasn't there?
well, that's still pending. I mean,
Okay.
there was a judgment entered on March 5. Why are you guys filing two separate actions?
You have one, he hasn't paid rent. And the other one is he's not following community rules. They're separate and distinct.
Did you know about this other case?
I didn't.
Why didn't you? Well, let's take care of the one I was out on first of all. What do you want to say, Mr. Captain? Anything?
I mean, I was out there this morning. I mean, there's dog excrement that's sold, but there's actually blue product. All right, I have photos. If Your Honor would like to see it.
I was out there.
Yeah.
I stood right next to you. I didn't see enough. I'm not throwing him out based on what I've seen. He's cleaned the property up immensely. So
So let me ask Your Honor this.
you don't have to ask me anything. You can make an argument to me. You're not gonna ask me anything. Go ahead.
So every single time that Mr. Castillo, doesn't follow community rules, procedures, the only way to get him to do this is to get him in court and have the judge go over there and look at his property twice. That's not right. Okay?
Okay.
No, that's not. So this is the promise keeping business. And Mr. Castillo has not kept his promises. We have. He hasn't. I believe that we've proven enough just through the course of this individual case.
What was wrong with the property today?
What was wrong with it? Well, from the short time that I was there, the first thing that I looked at was dog food right on the overgrown lawn. I mean, you can.
Overgrown lawn?
You want to see that? Come on, you're moving.
Mr. Captain, tone it down.
I'm sorry.
You're not gonna argue with me.
I'm not right.
You're not gonna yell at me. And I was there. I saw it.
Okay.
Let me see your photograph that you're gonna tell me makes the lawn overgrown in the middle of March or the latter part of March.
Please.
I don't know if it's possible for a lawn to be overgrown in the latter part of March. What was that? What is this?
There's your dog excrement. It's been sitting there forever. And the reason why it's long is because he hasn't cut it. So it's been like that through the whole winter.
You got here, failed to maintain the exterior of your home and home site in accordance with the community rules and regulations by failing to paint or stain the steps, failure to power wash the home shed and awnings, failure to maintain landscaping, failure to remove improperly stored outdoor items. I think those are pretty well done. Failure to remove debris and bulk items from the yard. Other than on the porch, where he had some things that I'm not excited about that aren't going to rise to the level of violation of community rules and regulations. I didn't see anything that was that bad. Failure to replace damaged window treatments. Failure to maintain the general clean appearance of the home sites. You're asking me for a just cause termination, and I'm not going to grant it. There's not even a triable issue here at this point. I'm dismissing this case. Case dismissed. And Mr. Castillo, listen to me. He does raise a valid point. You can't live in a community. Now, if you lived out in Monroe County on your own property where there's nobody else, you do what you want. I mean, as long as you're complying with city or township ordinances. You can't do this in a community. And I've gone out of my way here, he's correct, to go see the property twice because I hate to see you lose the home. Now, I'm going to tell you something. I'm going to remember this case, and it's going to come in front of me if it comes back here. And if I have to go out there and look at that property, I mean, this is twice, right? I went last Monday and this Monday. I'm going to remember it, and I'm not going to be forgiving about it. Do we understand? Fully and complete. Now, do you have the money to pay on this other judge
I absolutely have all the money.
for the lot rent?
Yes, absolutely.
How much you have? This judgment, and they brought it to my, honestly, I don't remember every case I call here, okay? I mean, there's a lot of people with a lot of familiar names, sounding names, and I did not remember this was you, or I probably wouldn't have granted this, but I got this back in February. They never filed an application for a writ. This is for $1,766.73. Do you have that to pay?
I haven't looked at that. We have the people, right?
Judge, just to clarify, Judge, they did file a writ. It just has not
They-
been signed yet because we had court today.
I see. I see. Paid today.
Um,
Pardon?
I do right now.
Get the money. How do you have the money? Are you prepared to accept the cash?
No, because if it's past the 10 days, he should have paid it, Your Honor, and we demand a writ. I mean, that's what the law requires.
Why didn't you pay this?
I didn't pay due to, that was advised to keep all contact away because they had held my rent when I sent it in December. After being, after judgment to put it in for the 26th, I put it in. It was held until after the 2nd. It wasn't cashed, due to this circumstance right here, due to filing for this.
Okay, so you filed on the other one. They weren't accepting the rent.
They didn't accept my rent. I put the money orders in and they weren't cashed until after the new year. I had put them in on the 26th when I ordered and they weren't cashed when they returned to the office. So I was advised not.
Are you on this, or do you want me to get the lawyer that was on this? I don't know who was on this.
Yeah, I wasn't, I don't know what he's talking about. It doesn't even make sense.
Well, I'm not signing the writ without a hearing. So Jennifer, I told you what I'm doing. I announced what I'm doing on the termination case. And on this one, I want you to set that. We don't know who was on this case.
Your Honor, if you're up, we'd like to just, maybe hold off, maybe a half hour. I can get prepared for whatever questions you have.
Well, you can get Mr. Levine. Mr. Levine's on the case, it looks like. It looks like. I could be wrong. I don't know who was on this. Who's got, it looks like a 3P number.
Oh, 3?
It looks like, it could be 6-3, I don't know. Looks like a parentheses and then 31797. I'm gonna show you this signature. Maybe you can tell who from your office there that signature.
No, that's it.
What was the P number?
Looks like David with me, he's 31797.
That's what I was thinking.
Yeah, and he's in Florida, so.
John R.
Oh,
John Artoon,
1797.
is he with your firm?
no, that looks like David.
They want to send you, they can send you. When did their office refuse to accept rent?
They took my money order, I turned it in on the 22nd.
Of what month?
26th of December. They wasn't cashed till after January 2nd. I called on January 2nd, had to cash. And I know I called, probably, I believe it was 2 days later, it didn't apply.
Well, why didn't you pay the February and March rent?
I was told to just leave everything in.
By who?
I called them. They told me to-
Okay, I don't want you to know, I don't want to know what your lawyer told you. You're gonna have to file a motion to set aside the default. That's what's gonna happen. And I'm gonna set the date for motion for entry or for entry of a writ. I'll set that for hearing your application for a writ. So we'll set the hearing on application for writ Motion to set aside default judgment. Jennifer, I want to put this in next week sometime if I can.
The 30th at 9:30, next Monday,
Which one?
March 30th at 9:30.
Technically, he's required to e-file it that day. Why don't we do this? Why don't we do it on the 1st of April? Can I fit one in there?
On Wednesday.
Yes.
Let me just pull that up.
So you file your motion
Um,
to set aside default judgment today. You understand?
No, I don't.
You're gonna file a motion to set aside default judgment on this second case, the one I just called, 2600528. Hearing on application for writ and motion to set aside default to be set for what date? April
You want April
1st?
1st, 10:30.
at 10:30. What do I have that morning?
You have Brownstown. There's an
That'll be-
arraignment at 10:30, so that's
That'll be
And then-
fine. That's what I'll do. So you guys can, I don't know who's gonna appear on this.
By
Mr.
Zoom,
Captain.
Judge?
Pardon me?
by Zoom.
Yeah, you can appear by Zoom.
Okay.
But I think I'd like you bring your money. You understand? I know. Well, don't forget it. You come in person. Although they won't have anybody here in person. I'll figure it out. You bring your money.
I have a pay today.
Not really, because you have a judgment you didn't pay within 10 days. Okay? I've never seen firms though, Mr. Capitan, file two separate actions, a just cause termination and non-payment of rent. They're ongoing at the same time. And if they're going to do that, there should be an indication to the judge, and the second filing should have to say there is another action pending. So I was just told you got another one there. One's in front of me and one's in front of Judge Hess. I'm not saying you, but your office. I've never seen them do this before. I've never seen any office do this before. So I don't know if there's just a some kind of misunderstanding or what have you, but I've never seen that happen. That's all I'll say about it.
I'm sorry, this is the first firm that does landlord tenant that I've been with. I've practically, I've seen federal.
I've never seen them do that before. But anyway, we'll work it out next week.
You gotta take that phone out of here.
The phone has to leave, sir. Got to take the phone out. Phone's got to leave the building now, please, guys. Please, sir, phone out of building.
Yeah.
We got signs all over. They have to be muted. All right, that's what I'm doing. Thank you both. Have a good day. Thank you.
Alrighty, everybody. Once again, good morning, TCF Live. Happy Monday, or as happy as your Monday can be, however you want to look at it. Let's go to Wexford County. It looks like Judge Elmore is going to do a sentencing.
Nick Carnes on behalf of the people.
Thank you, Honor Taylor and Anna Cavento on behalf of Mr. Baylor, who joins me at council table.
Thank you.
All right, court also recognizes before it this morning, Mr. Stephen Saladay. He is the agent from the Michigan Department of Corrections who prepared today's pre-sentence investigation report. We're here today for sentencing on this case in which there were 5 convictions. 1 for unlawful driving away of a motor vehicle, failure to report an accident to fixtures, home invasion, attempted assault, resist, obstruct a police officer, and a operative while impaired. Does that say attempt? On the PSI, CFJ 145, page 1. I just think that's probably a typo.
It was an attempted R&O. I think that was the only.
Yeah, I'm just saying, the attempt RO is listed there, but if you look on CFJ 145, page 1 on the 5th chart, it says attempt.
That's an area. I think that's that they struck.
Also, at the top of that page, we're going to change the sentencing date. That originally must have been set for sentencing last week, but due to the storms, we had to cancel court. Also here today, Mr. Hartel represents him previously.
Thank you, Your Honor. Yes, Mr. Hartel has covered me a few times in this case. That is correct.
I don't remember how your program works. Can you put in like a dash or a slash and put Ms. Fioravento's name as well? Yeah, great, thank you. Fine. All right, does not appear that I made any other notes for corrections. Let's go ahead and turn it over to the people. Mr. Carnes, did you have any amendments, corrections, or objections to make today?
Yes, Your Honor. If you CFJ 145, page 2, the jail credit should be adjusted.
Oh, yeah, thank you, thank you. Yep, so we need to add another 7 days, or, yeah, 7 days to that. Thank you. We've got 212 days. We're going to extend that date from March 15th to the date of March 23rd.
CFJ 284, page 1. In the second paragraph, says count 8 attempted police officer resist obstruct a 2-year felony. Since it's an attempt, that should be.
Yeah, it should be a 1 year.
1 year.
Yep.
And then in the 4th paragraph, second sentence, he's also abused opiates in the past. And then Galaxy gas, I looked this up. It is nitrous oxide, not helium gas.
All right. Any objection to that, Ms. Fioravento?
No, Your Honor, thank you.
Thank you.
And then on CFJ 284, page 4, just out of an abundance of caution for any appellate issues, I would ask that you strike just above consecutive sentences that delta 9 carboxy THC amount, as that's not admissible in an LWI case. But we keep the delta 9, which is admissible.
Oh, the carboxy portion.
Yes.
Yep. All right. We'll go ahead and make that change. Thank you.
That is everything I have. Thank you.
One more. All right, Ms. Fioravento, same question.
Thank you, Your Honor. I have reviewed the pre-sentence investigation report with my client. Other than what has been noted by Mr. Carnes, I would not have anything I would bring to the court's attention at this time. However, I would also note that my client does have limited reading and writing. We've gone through it to the best of my ability. I do not see anything that jump out, and we are not contesting what has been summarized based on what was in the police report. That seems a pretty accurate reflection of what was in the police report. We're not going to get into nitpicking any details, though, of what was in the police report. Thank you.
All right, thank you very much.
Mr. Baylor does have a guardian who just tuned in as well.
Oh, thank you very much. Also joining us now this morning is Mr. Baylor's guardian. This is Lee Storch. Am I saying that correctly?
Yes, Your Honor.
That's spelled Storch. Lee is L-E. All right, let's go ahead and turn it over to the people now. Oh, yes, ma'am.
I just want to verify, did the court receive our mitigation report that was submitted back in November?
Yeah, yep. And looks like you said November.
November 4th of 25, Your Honor.
Yeah, it looks like you must have submitted a second one.
And then I also, so our social worker submitted a mitigation report on 11/4/25, and then I submitted a sentencing memo on, I'm sorry, I don't have the date on my copy, but it was the week before last.
I do, March 13th. So yes, in fact, On the first one, I had written the phrase, "Why is this so old?" And then I got the other one on last Thursday or whatever, I think, or whatever it was, a couple weeks ago. Yep.
And if I may also elaborate a little on the procedural, why the mitigation was report, that was when Mr. Hertel was covering for me. I was on maternity leave, and that was right around the time I had went on maternity leave. So the plan has been, and I'll get more into this in my allocation, but the plan has been to plead for a bit now.
Yeah, no, it's okay. I understood it. Once I got the other one, I had them even pull up the file. I noted that it was so old. First one, I figured that out. And again, that first one was actually prepared by the social worker, Mr. Heiniger, H-E-Y-N-I-G-E-R, who works for the public defender's office. Again, that page, that one was actually 3 pages, although there was a 4th page with an attached email. And then again, Mr. Vento submitted what would have been the Friday before if we had done sentencing last week. Copy. All right, Mr. Carnes, why don't you go right ahead?
This is kind of a shocking series of events that occurred here. I read it for the first time this morning. And Mr. Taylor was in extreme danger. Our entire city Cadillac, or at least a portion by the high school, stealing a car while intoxicated by alcohol and marijuana, running it into the high school sign, causing significant damage, and then running from police. I absolutely think this kind of conduct merits a prison sentence. However, then I do get to reading about Mr. Taylor's past and difficulties he had growing up. And I do also look at his age, and I think the Department of Corrections recommendation here for a 12-month jail sentence and probation is ultimately reasonable. I would ask the court to sentence to 24 months probation, however, not the 18 that's recommended. Thank you.
Thank you. Mr. Vento.
Thank you, Your Honor.
Your Honor, I'm very sorry. Ms. Frick is here and does have a victim statement to read.
I saw she was here, but she was sitting by herself, so I thought maybe she was going to tap you on the shoulder or pass a message. I'm sorry. Go ahead, ma'am. This is Rick from the prosecutor's office. She is their victim advocate coordinator. Yes, ma'am. This statement made by.
Get that paper away from the microphone.
Oh,
yes.
Thank you.
On the early morning of March 27th, 2025, changed my life when I went out of my home to go to work. And in the darkness, after I started my car, Andrew yelled at me to take you to Mesa. Not knowing who you were or what you would do to me, I ran into my house and locked my doors. You then proceeded to steal my 2022 Chevy Trax and crashed into the Cadillac school brick sign and totaled it. Do you realize how many kids you could have put in danger if school would have been in session? Then you had the nerve to come back to my house right after all of that, when my husband left for work to be with me, asked if you could pet our dog while going to our yard to steal my neighbor's car. I want you to realize how this has impacted my life. I used to love to take my dogs for walks, and now I look over my shoulder or walk the other way if a male is approaching me. I'm having nightmares that you get a hold of me and not make it to my house. My husband has to wake me up and calm me down from punching and screaming. I've been in counseling because of this incident. I had to buy another car with a higher interest rate and higher payments. We now have security cameras on our house. I'm a person who has a soft heart and never wish for bad things to happen to people. I sincerely hope that whatever your sentence is, the help you need, and have the time to realize how many lives you impacted on that morning. Lewis Walter.
Thank you, ma'am. Thank you, Mr. Carnes. Anything further?
One last note from Ms. Carey. She does want to see GED completion as a part of it.
Certainly. Certainly. Mr. Vento.
Thank you, Your Honor. Mr. Failer appears before the court today as a different person than he was when he committed these events, and he's made significant progress. Background on the situation: at the time, Mr. Failer was 17 and he was on juvenile court probation. Because of these events, he was then bound up to this honorable circuit court. He was then, as part of his juvenile probation following his events, placed into the Ottawa Center RISE program, which he successfully completed and which we've included proof of in our mitigation report. Following completion of that program, he was transferred to the Wexford County Jail, where he has remained since, and he's already at 212 days credit. To my understanding, since being transferred there, he has had no behavioral issues while in the jail, and at this point, he has been sober for a significant period of time. He realizes that alcohol is a major contributing factor as well as other drug abuse. And the mitigation report gets into the situation that he presented himself in growing up. I would also emphasize to the court that twice during these proceedings, Mr. Failer has been examined for competency. He was examined in the probate court proceedings, and then once bound up to circuit court, I also requested an evaluation. He was again found to be competent and criminally responsible. But I would emphasize, as I noted in my request before this court in the probate evaluation, he was borderline. That said, he has significantly improved, and he would like to address the court today. The drugs and alcohol are the underlying problem here. I think we can all agree to that. Mr. Failer has had the time to truly reflect upon his actions and realize that the path he is going down is quite dangerous, especially for someone who is already has risk factors due to where he came from and due to his other developmental considerations and background. I would emphasize the snow factors here, which I also discussed in my sentencing memorandum. Most important factor is protection of society. Even a maximum prison sentence here, Mr. Failer would eventually be released. The goal is to keep him on this track of rehabilitation and sobriety. We have an opportunity here to give him the tools he needs to stay sober, and he has a motivation to do that. This is his first taste of the adult criminal system, and it has certainly taught him it's very different than the juvenile system. He does not want to be caught up in this system again. The next factor is punishment of offender. While this was very serious, and we do not downplay that, and Mr. Failer, again, he would like to speak on the danger he presented, and he realizes he could have killed himself or someone else. Something that he might not have realized at the time. He has made that progress though with the RISE program, participating in counseling while at the jail, and he has also taken steps to get a guardian. He did not oppose the appointment of Ms. Stewart, who joins us via Zoom today. Third factor is deterrence. Again, I emphasize that this has, and I got ahead of myself a bit in my allocution. Going through the adult system has taught him the lesson, and giving him tools through the RISE program, through abuse and neglect, through the NA and AA courses in the jail, and through the assistance of Ms. Storch, have given him an opportunity to take advantage of factors to become sober and stay sober and learn needed life skills. The final goal is to rehabilitate. Mr. Failer is young. He has the ability to turn things around and become a productive member of our society. He has already shown through his acts since these events occurred that that is his goal, and he is capable of doing that. We ask that he continue to be given those opportunities. Now, he realizes that there is still some time in jail that may need to be served, and he welcomes what the court thinks is fair and proportionate given all the factors of this situation. That said, we just respect the request that he be able to remain in county. He's been working on building up connections with community mental health and local connections so that upon his release, he will go somewhere stable and be able to continue his efforts towards long-term sobriety, towards his GED, towards a career, towards becoming a normal and productive member of society. If sent to a prison, he may be extremely limited in his ability to access those resources. And upon his release, he would not have built up those connections to the community that he is going to need for that transition. There's also concern about the guardian's ability to contact him in that situation. His guardian is also a great support, which he didn't have before. She is able to help him navigate necessary resources so that he has housing and medical care as a way of paying for his day-to-day needs, things which did not exist before. Previously, when he was before this court, he was a homeless youth. In consideration of all of these things, Your Honor, we would just respectfully request the court order any additional jail time be served locally so that those connections he's been working up do not get severed. And also, he is willing to consent to whatever probation or probationary terms the court believes is necessary. He realizes that if he makes any mistakes, that the court cannot be as merciful as it may be with others due to the severity of his offenses. But in consideration of all that, we do respectfully request common time with whatever probation the court thinks is necessary. I will allow Mr. Taylor to make a statement.
Mr. Taylor? If it helps you to read that by sitting down, you're able to sit down. That's fine. I know your hand, it restricts your hands.
Your Honor, on this day, I am asking you for a fair sentence. Also to take into consideration that I interfered and very sorry to the city of Cadillac to put people in harm. That night I took the cars. I am so lucky that I did not kill, hurt someone or myself. I think if you give me permission, I will complete it without very doubt or failure to report. I am already shown the court that I am capable of completing a program like the GROFF program. I also would like to say that I never want to drink again because I make really stupid decisions. That's all I have to say, Your Honor. God bless you and drink.
Thank you, Andrew. Mr. Feeler, since you've been in the jail, have you met with community mental health?
Yep.
How often have you met with community mental health?
Before I had argument with someone in the program, I was there doing CMH every day. Not every day, every Thursday.
Okay. And when did you have that disagreement with somebody else in the program?
Couple of weeks ago, it got physical.
Okay.
I would say that.
Explain that to me.
We had an argument and I lost my temper.
Okay. And so this means that what I'm interpreting here is that you had some physical confrontation with another person who was there as an inmate at the jail. Is that right?
Yep.
Okay. Now, when this occurred, where were you living? Were you homeless at a period of time?
Yes, Your Honor.
Okay. Where do you have to go live next?
The shelter.
The shelter?
Till I get my health card insurance and
Okay.
go to CMH.
All right. Ms. Storch, does Andrew have a place to go live?
Actually, right now, I have to get his Medicaid back. We have to get him into CMH, get CMH to agree to bring him into the system with them. And then my hope is to get, we know of a really nice AFC home down in Grand Rapids area, just to give him a change of pace and more structure. But as of right now, I can't do any of that until I can get CMH involved and get Social Security or whatever financial stuff he's got.
All right. Andrew, what kind of relationship do you have with your father?
It got better since I've been in jail, but me and his wife, do not get along that good.
Okay.
And fights in the past that got physical, and I don't want her anymore.
You don't want her around you anymore?
Yeah. But I do love her and my stepmom.
Have you I don't remember here. Hold on. I'm actually, I think I recall. Have you been working anywhere?
No.
And it looks like you have a couple siblings. Are those sisters?
Look,
Yeah. And what kind of, are they older or younger than you?
older, I'm the youngest son.
Okay. Mr. Saladay. What I'm kinds of things do you think can be done to help him get his GED, finish education? And what I'm hearing now is it's not so much about placing him locally, because the idea is to try to apparently get him into an AFC home down in the Grand Rapids area or some other area.
Maybe we would refer to Michigan Works for GED assistance.
Okay.
In town, but I'm sure it's available in any county.
Yeah. Well, let's look at this. This presents, I'm going to say a few things here, and I don't mean to disparage other judges or courts or legislators or other branches of the government, but it's a problem that gets talked about. That, I mean, the defendant's age. The defendant's 18 years of age, and there has been a lot of discussion out of Lansing, whether it's from appellate court rulings or the legislature talking about what do we do with young people, and we shouldn't put them in jail. Whenever these conversations seem to come up, it's always about prison is in jail is horrible, and that's the antithesis of what our objective should be. Maybe that's great. It only means something when they say that, and then they give us money locally to help establish and run better programming or put programming inside of a jail. I have an 18-year-old man here who has been failed by his parents and failed a little bit by life here. He's made his own sets of bad choices, but he's also struggling a little bit with some developmental and educational slowdowns. I'm trying to say that to be very respectful to Mr. Failer, but he does. Let's just call it what it is, because I have to identify what his needs are. That's the only reason I mentioned this. I have young Mr. Failer, who is off to a very, very difficult start. It would be easy for anybody to look at this and say, wow, this is horrible. So you add in the fact that he's 18 and he's been failed by all those the resources that many of us already have, or we give to our own children. We had it growing up, and we give them to our own children today. Mr. Failer began using substances at the age of 7, I think was the earliest age for marijuana, alcohol, 12 for the use of opiates, and over-the-counter intoxicants at the age of 16. He has seen and consumed more types of substances than I think most people do in their lives. And this is a perfect example of what happens when young people are allowed to gain access to alcohol and marijuana. There are several offenses here that the defendant is, of which the defendant is guilty, that I don't even know if they were charged. Maybe they were. Hold on. He already got some benefits from some reductions, but unlawfully possessing marijuana, He's unlawfully using marijuana. He's unlawfully transporting marijuana. He's stealing marijuana. He is stealing multiple cars. He's driving both drunk and high. And took off running from police. This all started because he was one, drunk and high, and wanted a ride to a girl's house up in Basic. So if I were to look at this and I were to say, if I ignored the defendant's history, I'd be sending him to prison without a doubt. He scores straddle cells for 2 of the felonies, and it would be very easy for me to do so. And I don't really know what to do, considering he's had a terrible upbringing. But at the same time, with a terrible upbringing, everybody says that jail or confinement is bad. That doesn't mean anything if you don't. Well, prisons have got skill trades, training, education, GED, getting his license, getting an identification card, getting other things in order for him. We also want to help maybe give this young man a chance. He's already got several strikes against him. Mental health issues, educational issues, sex offender registration from an offense in 2024. Then while he was on probation for that, he picked up another charge that was another R&O. And then he picks up this case, and you're talking back to back. Some of them overlapping. In fact, this one was also while he was on bond, I think, for the previous one. And I won't go into a lot further because I want to respect, even though there's a lot of good opening stuff up about the defendant. There's some other private information that's contained in the family narrative on CFJ 284, page 7. That he's experienced as well. Now, those things, of course, don't make the court say, all right, well, because of that, I take this point off, I take that point off, I do this. Got to talk about it because this is a really difficult situation. All right. By the way, I did read both of the mitigation reports. I had notes on them. I talked about the father and stepmother because in it talked about him repairing and strengthening his relationship with the stepmother, but I could sense there was some issues with the stepmother. Mental health. Oh, by the way, he hasn't completely behaved well in the jail, so we have a little bit of an issue there. But regardless, I appreciate the efforts in those statements and the memorandum from the. Here's what the court sentences. Court places the defendant on a period of probation. I go higher than what anyone else has asked for. I'm going to go to 36 months. The court adopts the terms and conditions that are listed on CFJ 145, pages 2 and 3. The court finds those conditions are well suited for rehabilitative purposes, considering the defendant's need for education. I want to make sure that the GED or education language is in there. Is in there, Mr. Salad, and don't always recall what paragraph it is. I see, obviously, not possessing alcohol, other intoxicants, controlled substances, testing, treatment, rehab. All that, of course, is appropriate.
And in there, Your Honor, I'll make sure it's added.
Thank you.
No objections.
Thank you. All right. With that period of probation, Mr. Failer, you'll have the right to be considered for an early release from that probation after 18 months, as long as you are compliant with all the other conditions. If you are not compliant, then you'll have to do the whole 36 months. And while you've had some issues here, I'm going to say that I don't know if you only had these issues really over about a 1 year gap, a 1 year, sorry, 1 year period of time. Well, we are now, along with Miss Storch, who's going to be your conservator here. All right, we are going to become your uncle and aunts as well. Okay, I'm going to be supervised, and I'm going to hope that the people, I trust that the people are positive and are going to be there to help you. Okay, that's their job. That's why they do the job, and that's why I trust them to do it. There are $268 state minimum fees. Two. Do we, well, you know what, I'm gonna explain, I don't, if it's a high court misdemeanor, does that $68? So it's three.
Should be three.
Yeah, that's why I'm asking the question. All right, so we got $368 state minimum free fees, two $50 state minimum fees for the two felonies, one $130 crime victims' right fund fee. The court's going to assess a $200 court cost. That's less than what I typically would add. Or there wasn't any restitution, well, was there?
Yes.
Because of the sign.
There's the sign and the car's deductible.
Yep, hold on. Have that amount on here, I'm sure you did.
It is in the PSI here.
It is amount of restitution of $5,500. And that is the first $5,000 goes to Cadillac Area Public Schools for the repairs of the sign. And the $500 goes to Sue Lewis Walter for restitution for the vehicle for her copay.
Yes.
Deductible. Thank you. I'm not going to assess any other fines. Going to assess a $200 attorney fee. We've had two attorneys involved in the case, plus the help from their social worker. Plus, we had to do it. We have to do a DNA because we would have had DNA when he had the CSC as a juvenile.
Okay, that makes sense to me now. I have no DNA. In the file,
Yeah,
so.
it makes sense that he had it as a juvenile. Yep, I see him shaking his head. We're good. So I've already covered the restitution of attorney fees. Now, as for a period of confinement, my concept here, thought process is I'm going to help give Ms. Storch and Mr. Saladay some time to help make the plans, help get them out, get them into treatment programs, set up this AFC home, things like that. And the defendant receives for each one of these charges 212 days of credit. That makes it really easy for count two. So that's a 90-day sentence with 212 days. For count four, the court's going to sentence the defendant for the attempted R&O 212 days with 212 days of credit. And for the fifth count, the operating while impaired, it is 93 days, which is of course the maximum with 212 days of credit. Now that takes me back to the home invasion and the unlawful driving away. In each of those cases, the defendant scored a straddle cell, and taking into consideration all the factors that I've talked about here today, the court finds that the proportionate and reasonable sentence here is as follows. 1 second, I've got to do some math. Count one and count three. 300 days with 212 days of credit. Ms. Storch, that means he's got about 28 days or so to serve. 1 second. I'm sorry, 38 days left to serve. Should give everybody time to help set up the right tools that they need to help supervise. All right, Mr. Saladay, have I missed anything? Lawyer. Mr. Carnes, anything else?
No, Your Honor, thank you.
Ms. Firavento,
No, Your
anything
Honor,
else?
thank you.
Mhm.
Can somebody just make sure that the probation officer knows how to get a hold of me, please? For their office, is that how it
Yep.
works?
Yep, hold on. We just don't want you saying everybody's phone numbers out here. So Ms. Firavento will make sure that Mr. Saladay has that number.
All right, thank you.
You're welcome, man. Thank you for Mr. Failer. Let's hope we can get him into programming and get him set up for a job and have him get set up for some education and so forth. Oh, that probation, by the way, Madam Clerk, only applies to the felonies, count 1 and 3. All right, Mr. Failer, Ms. Firavento is going to bring to you 2 copies of 1 document. This document tells you of your appellate rights. You're going to place your initials on the first copy. Now, when you place your initials on that first copy, you are not electing nor waiving any rights. You are merely acknowledging your receipt of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. And while that is typically done by filing a claim of right to appeal based upon the plea, in this case, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want me to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return to me in 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. Do you understand, Andrew? Andrew, I know you've had some difficulties, but those cannot always be an excuse. At some time in life, those difficulties will no longer be an excuse. So let's learn from them. That's the thing that I hope for you. Learn from them. And I was really impressed by the statement read by Ms. Frick today. That person didn't call for the harshest punishments. They didn't call for prisons. Even though she talked about how it, quote, changed her life, she also said that she hopes you get the help and treatment that you need. I really appreciate that person's strength and respect. Any questions?
No, Your Honor.
Anything else, Ms. Firavento?
No, thank you. May I approach?
You may. Thank you. We're adjourned.
Okie dokie, friends. Let's make our pilgrimage down to Florida. We'll check in on Wade Mercer's first appearances.
Hey, thank you. Corporal or Mr. McDaniel, can you see and hear both of us?
Yes, sir, we can.
Perfect. We have one person that may need the services of an interpreter. Mr. Ricardo, good morning. We have David Gabriel Aguilar. Mr. Ricardo, if you'd please introduce yourself to Mr. Gabriel and make sure he can hear you.
Very well, Your Honor. Good morning. Muy buenos días, señor Aguilar. Mi nombre es Jordani Ricardo. Yo soy intérprete para que se pueda comunicar con el juez. ¿Me escucha bien?
Sí, sí.
Okay, he can hear me, Your Honor.
Great. Mr. Gabriel Aguilar, you're here because you've been accused of 1 count of driving with no valid driver's license.
Señor Gabriel Aguilar está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
In addition to that, you've also have a hold from the United States Immigration Agency.
Además de eso, también tiene una orden de retención de parte de la Agencia de Inmigración de Estados Unidos.
I am appointing the public defender's office to represent you and asking that you listen to your attorney, Mr. McDaniel.
Le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Gabriel. He's in a plea of no contest to the charge as listed. The understanding he'll be sentenced to 2 days in jail, credit for 2 days, and a $400 fine, which would be a civil judgment.
Su señoría, he hablado con el señor Gabriel. Él se va a declarar no me opongo ante los cargos, entendiendo que se le va a condenar a 2 días en la cárcel con crédito por los 2 días que ya ha cumplido y que tendrá una multa de $400 como un fallo civil.
Waived his right to a jury trial and call witnesses and understands that any plea can result in deportation.
Él ha renunciado a su derecho a un juicio con un jurado y a llamar a testigos y entiende que cualquier acuerdo en un caso penal pudiera resultar en la deportación.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Gabriel, did you hear that agreement, sir?
Señor Gabriel, ¿escuchó usted ese acuerdo, señor?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Por ejemplo, tengo que esperar otros 2 días o tiene inmigración por mí.
What, do I have to wait 2 more days or is immigration coming to pick me up?
Immigration has 2 days to pick you up. If you're not picked up within 2 days, you'll be released.
Inmigración tiene 2 días para recogerlo. Si no lo recogen en 2 días, lo dejan salir.
That 2 days starts now.
Los 2 días comienzan ahorita.
Any other questions?
¿Alguna otra pregunta?
No, eso es todo.
No, that's all.
Is this the plea you would like to enter?
¿Es este el acuerdo que desea aceptar?
Sí.
Yes.
Mr. Gabriel, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license, withhold adjudication of guilt.
Señor Gabriel, acepto su declaración de no me opongo ante el cargo de no tener licencia de conducir válida. Le suspendo el fallo de culpabilidad.
I'm going to sentence you to 2 days in jail and give you credit for the 2 days you've already served.
Lo condeno a 2 días en la cárcel y le doy crédito por los 2 días que ya ha cumplido.
I'm also imposing the court costs and fines set by state and county law of $400, which will be a civil judgment.
También le voy a imponer la multa y costas estándar establecidas por el estado y el condado de $400.
So your local charges are over with, sir, and they have 2 days to pick you up.
Entonces ya ha terminado con sus cargos locales, señor, y ellos tienen 2 días para recogerlo.
Do you have any questions?
¿Tiene alguna pregunta?
Tengo que pagar, o sea, después de eso ya me dan 48 horas.
I have to pay, so after this, I get 48 hours.
If you don't pay the fine, then the judge will be sent to a collection agency.
Si usted no paga la multa, el balance lo envían a una agencia de colección.
And then eventually the clerk's office under Florida law will have to suspend your license if you had one.
Y entonces, bajo la ley de la Florida, la Secretaría Judicial tendría que suspenderle la licencia, si es que tiene una.
But if the Immigration Service does in fact deport you, and I don't know if they will or not,
Pero si inmigración termina deportándolo, y yo no sé si lo deportarán o no,
if they deport you, it really doesn't make a big difference. The fine doesn't.
si lo deportan, entonces en realidad no hay mucha diferencia. La multa no tiene diferencia.
So you may want to wait and see what happens with immigration before you even think about paying the fine.
Así que quizás quiera primero esperar y ver qué pasa con inmigración antes de siquiera pagar la multa.
The reason I say that is I'm assuming your family may need the $400 more so than the county or state.
La razón por la que le digo eso es que me imagino que su familia necesita el dinero más que el estado o que el condado.
¿Entiende?
Ok, está bien.
Okay, very well.
Have a good day.
Que tenga buen día.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
We have Dustin Freund next.
Okay.
Good morning, sir. You're here for first appearance accused of one count of child abuse without great bodily harm. I have read the complaint. There is probable cause for the charge. I've also looked at your criminal history, which I believe the Department of Corrections website shows you've been to prison 4 times. I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything? Thank you.
Nothing at stake, Your Honor.
Mr. Foyne, I'm going to set your bond at $7,500 cash or surety, given your criminal history and the third-degree felony that you're accused of. It does have a condition. Your bond has a condition of no contact with the alleged victim. Now, I know that you were, according to the complaint, you were living in the home with the alleged victim is your stepson. So at least for the time being, you cannot go back to that home if he's still living there. I have no idea who owns the home, what the deal is with the home, but you can go somewhere else. Obviously, you just can't go there if he's still living there. If he goes and stays with someone else, that's a different story, but no contact with him at all. Sir, you'll get to use the phone after first appearance to try to post the bond, and the jail will give you a notice after first appearance for your court date, which will be April the 7th at 8:30. Do you have any questions? Have a good day, sir. We have Elijah Riley. Mr. Riley, good morning. Mr. Riley, you've been accused of 5 new criminal charges and a violation of probation. The new criminal charges are possession of methamphetamine, tampering with evidence, possession of marijuana less than 20 grams, refusal to submit to a DUI test, and possession of drug equipment. Mr. McDaniel, would you like to be heard on probable cause on any of those?
Judge, just probable cause for DUI tests. I mean, there's nothing there on that. You gotta have probable cause for DUI before you test them.
Thank you, Mr. Mitchell.
Just a moment, Your Honor. Hold on. Yes, he is. I was looking to see if I could find any more about, it being charged by itself without a accompanying DUI, but I can't find anything at this moment. So we'll leave it up to the discretion of the court. What you want to do with that charge?
Okay, so I don't know that you have to have a charge of DUI, although I've never seen a refusal without a DUI. I don't know that you have to have charge, but I think Mr. McDaniel is correct because the statute, which I'm looking at now, says when the arresting officer has probable cause to believe. So you've got to have probable cause, even if you don't charge them. So then the question is there probable cause for DUI? And I agree with Mr. McDaniel. There's not probable cause for DUI. There's probable cause. There was marijuana in the car and perhaps some other substance, but there's nothing about a driving pattern, nothing about, there's something about him, 2 field sobriety exercises, but that is after the arrest. And that's not enough for probable cause without smell of alcohol, weaving, swaying, bloodshot eyes, slurred speech.
It may have been good for something related to his VOP, but I don't think for a refusal in that situation. But
I agree with the defense on the refusal. I'm gonna find there's probable cause on all the other charges. Corporal, I asked the jail at the request of the probation office this morning for a urinalysis. Do we have a urinalysis, Corporal?
Yes, sir. I texted it to your phone. I just haven't had a chance to email it yet. I'll send it to you.
So according to, thank you. There was a text sent after we started. It was 8:31, so my phone's turned off, but thank you, Corporal. Say Mr. Riley was positive for meth and THC. So if you'll forward that email to both Mr. McDaniel and Mr. Mitchell will then provide it to the probation office. So,
yes, sir.
Mr. Riley, what I'm gonna do is go ahead and set you bonds on the cases. There is probable cause on the methamphetamine felony charge and the tampering are both felony charges. Those bonds will be $10,000 each. The less than 20 grams of marijuana and the possession of drug paraphernalia will be a total of $5,000 each. Your total bond is $30,000. You're not being held on the refusal. Do not try to post the bond, Mr. Riley, because of you being on probation. I'm gonna put a 7-day hold on you with no bond, which is what we always do. I always do. And that 7-day hold starts today. We'll see if the probation office has a warrant for you. I would expect, based upon your analysis, even if it wasn't for the new charges, to have a no bond warrant, but we'll see what happens with the circuit court gets a chance to review that. So I'll see you next Monday and we'll see if they have a warrant. If they don't have a warrant, I'll certainly release the hold and you'll be free to post the bonds in the other cases and be released. As far as special conditions, You would have a condition of random urinalysis if you're ever on bond in this case. But I'll see you a week from today and we'll see if they have a warrant or not. Any questions, Mr. Riley?
No, sir.
All right, sir. I wish you the best. We did want to give you a court date, Mr. Riley. Your court date is going to be April 7th at 8:30. April 7th at 8:30, the jail will give you that notice.
It would probably be for both the new law and its VOP.
Probably will, if they get the affidavit filed. Yeah. And I feel that they will. Probation.
Calhoun County can probation, so I doubt.
Oh, is it? That does
Yeah.
complicate things a little bit. Because you got two counties involved, but they still probably will. So, because y'all have the same office. Mariana's, well, notice, yeah, Mariana's out of the county. They may have one office down there, but I think the officers are typically up here.
I'll
aren't they?
email them and notify them it's out of Calhoun and they can get in touch with them.
Thank you. Next is Shay Skeen. Ms. Skeen is here for the charge of violation of probation in case 25-602 CT. Ms. Skeen, you're on probation for the charge of driving on the influence. You're accused of having a new arrest this month in Houston County, Alabama for public intoxication. That's the sole basis for the violation that you're accused of. I'm appointing the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
I spoke to Ms. Skeen. She's going to admit that she violated probation and her sentence. She gets sentenced 90 days in the county jail, 5 days jail credit, remaining fine and costs, whatever that is, and that'll resolve the case of that.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
So, Mr. Ham, do you have the remaining court costs and fines on Ms. Skeen?
Fine, $440 on our cost supervision.
Okay. 718 on your court costs and fines. I don't worry about cost supervision if there's a jail sentence without a purge. So, Ms. Skeen, is that the plea you would like to enter, ma'am?
Yes, sir.
I'm going to accept your admission that you violated the terms and conditions of your probation. Ms. Skeen, revoke that probation, sentence you to 90 days in the Jackson County Jail. Give you credit for the time that you've served. And Mr. McDaniel, I did not write that. Yeah, I did. It's 5 days credit. I did write it down. 5 days credit, court costs and fines that you have left of $718. That'll be a civil judgment against you. But Ms. Skeen, hopefully you can get that worked off at the jail. Ma'am, the trustee program at the jail does give you the opportunity to earn some extra gain time. So I hope you take advantage of that. Ms. Skeen, there's no probation involved in this sentence, ma'am. You finish this sentence, then you'll be released. Mr. McDaniel, I don't think it wasn't discussed in the text, but it appears Ms. Skeen might benefit from an inpatient alcohol treatment program. There are some that are about this long. No, don't think that's an option. Okay. If it's something that y'all want to look into, let me know. Otherwise, then it'll be the sentence I've just imposed. Anything else, Mr. McDaniel?
Just to remind you, she takes too many medications for her. I mean, she has serious mental issues and medication she takes. They would probably never let her in there.
Okay. All right. So, Ms. Skeen, you may want to talk to the chaplain, ma'am. Mr. McDaniel's correct. Most of the programs have very strict rules. If there's some program you want to go to that will work with your medications, and that's great, I'll certainly consider it because it looks to me like alcohol appears to be the underlying issue, and more specifically, the inability to refrain from the use of alcohol appears to be the underlying issue. Ms. Skeen, do you have any questions?
Will this affect my charge in Houston County?
I want to say the answer is probably no. Here's the problem. The problem is if you have a court date before you're out, then that could create issues in Houston County. But what will happen is when you're released, I'm going to ask the jail to give you documentation to take with you to showing the day you were admitted here and the day that you were admitted up, the day you got out. So, Ms. Skeen, the Alabama system, I believe, is a grand jury requirement for, is it all charges or all felonies?
All felonies, I know for certain.
So, I don't know about, I'm not familiar with their system up there on misdemeanors. It takes felony, it takes months and months to get to court because it requires a grand jury in all felony cases. You've already got a court date for May 4th? Yeah,
Yes,
you're going to be in jail. Yeah, you're still going to be in jail May 4th. I don't see any way. Even if you're in the maximum gain time, I think you're still going to be in jail May 4th. So my suggestion is that you let the public defender's office up there know your circumstance. You get a chance to use the phone after first appearance to do that. Also, we will send with you, when you do get out, we'll send with you the paperwork showing that you were in jail to the dates you were in jail. That way, if you miss your court date while you're in jail, you'll have some documentation of that. Any other questions, Ms. Skeen?
No, sir.
All right, ma'am. Wish you the best. I'm just looking at the math here. She has 5 days credit.
She ain't gonna get out by then.
It's about 6 weeks is what it is. So
Even if we did a 60-day sentence,
it'd be close.
it'd be right at the end. Mr. Mitchell, I toyed with 60 versus 90 when I sent out the tentative suggested offers this morning for you to review. I don't feel strongly either way. What's your preference?
I have no idea. I have no objection to amending it to 60 days. If I remember, the only history that she had previously was like a DUI from 2019 or something like that.
She had a little history, Mr. McDaniel, not much. That's why I said I was okay with the 90 days, but I don't want to cause her problems where she's got a failure to appear and a hold from Alabama when she's in jail here. So Mr. McDaniel doesn't object. You want to bring her back in and change it to 60 days? Or do we even need to bring her back in?
I'll let her know.
Okay, so I don't think I think that's in her. If she doesn't want to do that, obviously she can come back tomorrow and let us know that. But for right now, Mr. McDaniel, you're comfortable with us making that decision without her being in here?
Correct, Your Honor. I am.
All right, so I'm gonna change that sentence to 60 days in jail. Okay, so we're gonna change that sentence to 60 days in jail. It doesn't make a huge difference to me, but it does may make a big difference to her. Thank you. So that's, by the time you figure game time, could be 30 days or less, obviously. So, Mr. McDaniel, I think that's everything. Anything else from the Public Defender's Office?
No, Your Honor.
Thank you. Mr. Mitchell, anything else from the state?
Nothing from the state, Your Honor.
Corporal, anything from the jail?
No, Your Honor.
We appreciate it. I do have first appearances tomorrow, but not Wednesday or Friday. So we'll see y'all in the morning.
Good to know, Judge. Thanks for the scheduling update. Good morning once again, everybody. TCF Live on a Monday. The first Monday of the week. Only 4 more to go after this one. Great Granny picked up a poster from the Courtroom Files store this morning. Thank you so much for that. courtroomfiles.com. We've got lots of great merch over there, including our now world famous Adventures of Meth Boy and Rock Girl poster, which is what she picked up. Little story that we started on the pre-show a couple days back. Stand by on where that's going to go. I'm currently working on that. Anywho, let's go to Texas. Say good morning to Judge West.
Good morning, sir. You're David Biano. This is 25 DCCR 1212. Mr. Biano is charged with aggravated assault with a deadly weapon. And what is the announcement?
We just need one reset and we'll get it disposed of.
Okay.
We're going to supply, we've already supplied some records. We're going to get 3 more things, I think.
Okay.
And but by the next setting, the case will be disposed of.
Okay, thank you. I'll reset any issues.
No, Judge, I feel confident that we'll be able to work it out.
All right, Mr. Biano, I'm going to reset your case. Stay in touch with Judge Walker. He'll let you know when you need to be back. All right, thank you.
Thank you.
See, is Mr. Wasserstein here?
Yes, sir.
Good morning, sir. You have a Guadalupe Reyes?
That's you, Your Honor.
Yes, sir. How are you?
I think Mr. Reyes.
Here he comes. Good morning, sir. You Guadalupe Reyes? And this is 25 DCCR 1422. Mr. Reyes is charged with aggravated robbery. And what is the announcement?
Judge, I'd request one more setting. The last time I was in front of you, I didn't have a discovery. State held my hand and got me the discovery, which I think is voluminous. Haven't had a chance to go.
Okay, so we'll just do a normal reset. Mr. Reyes, make sure you make an appointment, go visit with your attorney so that you can go over all of the information that he's received. So we can get an announcement at that next court date. Any issues?
None I'm aware of, Your Honor.
Okay, thank you. All right. Thank you,
I
sir.
also wanted to thank your staff. The last setting I had while I was ill, they made it really simple.
Well, thank you, sir. We appreciate that.
Thank you. Thank you, Mr. Richard.
Mr. West, you have Miguel Reyna.
Sure. I'll get a 5-star review.
I like it.
Judge Deanna Paul from the initial setting. Right, I got her box.
Okay, thank you.
What's the name?
Miguel Reyna.
Is this the one that worked?
Yeah, he's here though. Or he's supposed to be
Oh,
here.
he just got hired in January.
Yeah, I'm still. Yes.
Okay.
It will be worked out, but I just need some time.
Good morning. Are you Miguel Reyna?
Yes, ma'am.
And Mr. Reyna is charged with driving while intoxicated third or more and cause number 25 DCCR 1687. And what is the announcement?
Your Honor, if we get a little more time to keep working on the resolution, I think we have something in principle. We just need some more time to get it resolved.
Any issues?
We discussed it Friday. I think we will be able to.
Yeah, I'm pretty sure.
Mr. Reyna, do you, you have the auto ignition interlock device on your vehicle? Make sure you keep that and don't drive any vehicle that does not have that on it. I'm going to reset your case about 30 days or so. Make sure you get with Mr. West, take care of everything you need to and visit with him, and then we'll get your case disposed of at the next hearing.
Yes, ma'am.
All right, good luck to you, sir.
Thank
Please, Mr. Wilkerson here. Mr. Burbank. Oh, there you are, Mr. Wilkerson. Are you ready on Larry Bigelow?
No, Your Honor, I need to talk to him. My client is here though. so-
I'll hold it.
Thank you.
Ms. DeLage, you've got a Christopher Pickens, 2 cases.
Yes, ma'am. Right here.
Good morning.
Good morning. How are you?
Good, how are you?
Good. I'll be better, I think.
Good morning. Are you Christopher Pickens?
Yes.
And Mr. Pickens is here in 2 cases, 24 DCCR 2275 and 2276. And what is the announcement?
This is the one we said it last time, Judge, to get a subpoena for the complaining witness in the
Okay.
case. She's moved out of state. We have sent a subpoena that has come back unclaimed. So the family has stopped communicating with us via phone or any other, been able to try to get in touch with every phone number that we've got for her. So if I can do the latest call.
Yes.
State would call Brittany Boyd.
Would you call the name Brittany Boyd, please?
What's your name?
Boyd.
No response, Your Honor?
With that, Judge, the state would file dismissal on these cases.
All right, I'll sign the dismissals as soon as they come through. Mr. Pickens, your cases are over. You're free to go. Thank you,
Judge. Thank you, Tom.
Mr. Gum. Mr. Gertz, you have Bruce Hill.
This judge, he's right outside on ground.
Morning.
How are you?
Good. How about you?
Good.
Monday.
Judge Christy Johnson is also here from the initiative side.
Okay. I'll go through those in a second, get them out of there.
Next one over.
Good morning, sir. You're Bruce Hill.
Yes.
And this is 25 DCCR 1348. Mr. Hill's charged with false name, information, or forgery of vehicle registration. And what is the announcement?
Judge, we're going to ask for one more resetting. Ms. Malfino extended an offer to me last week. I've talked about it with Mr. Hill. We kind of have a counter offer that we'd like to discuss with the state, counter proposal. But we also need to settle up some of our contractual obligations internally. And so if we could have maybe a normal reset to do both of those things, I think we can get this resolved.
Any issues?
No, Judge, he also has a video.
Right, so Mr. Hill, I'm going to reset your case to normal reset. Make sure you stay in touch with Mr. Gertz, take care of everything you're supposed to, go over with whatever information he gets or receives and offers from Ms. Malfini. We'll get an announcement at the next meeting. All right. Mr. Kimler, you've got Wayne Cummings.
Yes, sure.
Good morning, sir. Are you Wayne Cummings? Can I get everybody to kind of hold it down while you're visiting, please? And this is 18-29640. Mr. Cummings has a motion to revoke his probation, and what is the announcement?
Judge, this is a case where the new DWI charge that was alleged in the motion. I checked again this morning with the Orange County District Attorney's Office. That case has not been brought in. At this point, we would ask for one more reset. Given time, it's from October 25, so I would think it would be there, but they may wait on labs, and I know the lab has been backed up for a while based on personnel issues.
Okay. Any issue with, so Mr. Cummings, I'm going to reset your case, just another maybe 30 days or so. Stay in touch with your bondsman and Mr. Kimler, and they will let you know when you need to be back, and we'll see what the status of that Orange County case is at that time. All right. You're free to go, sir. And then you have Andrew Ritchie, Mr. Kimler.
Andrew Ritchie.
Andrew Ritchie.
I talked to him Friday at the office. They were just gonna go to the.
Morning, Ms. French.
Good morning. Apologize for being late. Couldn't be helped.
Sir.
On Friday. I talked to him. That's where you.
Good morning, sir. Are you Andrew Ritchie?
Yes, ma'am.
And Mr. Ritchie has a motion to revoke his probation and cause number 22-40568. And what is the announcement?
First state, Your Honor. You gotta understand.
Yes, Your Honor. In talking to the Officer Ruiz, his probation officer, it appears as though due to medical issues that apparently began almost immediately after Mr. Ritchie was on probation. We have had a discussion about what might be the best thing to do with Mr. Ritchie here. It seems that he has now been cleared medically, and please interrupt me if I'm saying the wrong thing, Mr. Ruiz, but he only was able to report 9 times since 2023 due to that illness. And he has completed a CSR. What we would like to do instead of revocation is extend his probation by 2 years to make up for the time he has essentially missed on probation, so that he has the full period.
Is that an agreement?
Yes, ma'am.
So we can do it 2 ways. If it's by agreement, Mr. Ruiz can just sign that modification order and you guys can dismiss the motion to revoke, or we can go through the motion to revoke and I can order it that way.
We'll sign. Oh, he has the ankle. That was something we can.
Well, we'll get some
Yeah,
first things
we'll get to
first.
that.
I don't have a problem with him being completed. I don't have a problem with that at all either. He paid for all his fees. He completed his community service. He did his anger management class.
So even without reporting, it sounds like he's done everything else he's supposed to.
So it's your discretion, but I don't have problems with him being completed.
Let me look back real quick at the I've got that. I was just gonna see if I had my old PSI.
And Your Honor, it's my understanding that he paid for his community service hours, not actually having spent the time doing community service hours. It's the state's position that he complete more than 9 months on the charge that he was given probation for.
No, I don't, I mean, I understand where you're coming from. Sounds like I need to see the PSI, but we don't know where it would be, do we?
State.
I mean, because, obviously they're given that opportunity to. You have one? Can I take a quick look at it? Thinking if there's. He obviously wasn't arrested for anything else during that period of time. Oh, look at one more thing. Yeah, just give me a minute to kind of make sure I have a full picture. Side. Should have numbers.
Yeah.
So what I'm inclined to do is kind of meet you guys in the middle, just based on the nature of the offense and just some of the issues, that I want to make sure have been addressed fully so that there's not this issue again is, I'll agree to a 1 year instead of a 2 year, extension. So that started, I guess it would start technically January. So it'll be till January of next year. And make sure everything is going well. There's not any other issues that need to be addressed. And then if everything ever goes fine, then you'll be done in less than a year. If you'll sign that, then you can either you go ahead and dismiss that motion, or do you want me to go through the motion and rule on it?
I'll just dismiss the motion.
Okay, I'll sign that when it comes through, but you need to stay and make sure you sign that order with your attorney that you agree to that 1 year extension. I'm gonna leave that up to probation. Obviously, well, that was a condition of the bond because where are you living, Mr. Ritchie?
In Middleton right now.
Okay. And do you intend to stay? You say like you're not gonna stay there. Is that where you intend to stay or no?
I want to see if I can stay in Harris County or here, it's my job and I have a home there.
So you need to talk to probation about that. As the biggest thing is you have to report, you'll have to report in Harris County and by mail here for the rest of that year. And I don't have an issue with that. So because that GPS was the condition of your bond, that's technically over today. So you will be able to remove that.
Yes, ma'am.
Here's the thing, if you don't do what you're supposed to and report in mail here or by online and in person in Harris County, if it gets transferred, you'll be right back in here on a motion to revoke your probation and we won't have this probably nice of a conversation. Okay,
Yes,
all right. You visit with your probation officer before you leave. You can get that signed and he'll talk to you about the process to get it transferred to Harris County.
Okay.
Okay, thank you.
Thank you, Judge.
Thank you.
Alrighty, friends, let's change it up. Let's go up to Michigan. A certain Judge Cedric Simpson, never heard of this guy, has got some stuff going on.
Flag, we've had a bench conference in this case. I've read over the motion to modify bond. Anything else from the parties?
Your Honor, at this point, I would just leave it in the court's discretion. I did have a chance to speak with the victim today, and she did indicate that she was not afraid of the defendant, and would like the no contact order and no go to be removed. So at this point, I will leave it in the discretion of the court.
All right.
And I think the record should reflect that the complaining witness is present in the courtroom. And I did want to thank the court for accommodating us today.
Well, what was interesting is that my Ann was saying, well, I don't know, we'll get this. I said, Smith step and we'll figure. All right. The court having read it over, the court is going to change the bond conditions and will grant the motion to modify bond. I will delete the no contact, but add a no non-consensual contact. Do you understand that, young man?
Yes, sir.
All right, so she says to you, she doesn't want you around. You got to get out of there. Understood?
Yes, sir.
And I will also delete the no-go too. Press. All right,
Thank you, Your Honor. And then I believe we're also pre-trying the case if that's okay with the court today.
that's fine with me. What are we doing?
We'd like to set it for final pre-trial, Your Honor.
Jury final settlement conference will be April 10th, 2026 at,
Your Honor, I'm out of town that day.
that's the only day I have for that.
Okay. Perhaps I can find somebody to
Council approach.
stand in.
All right, let me see if I can bump us past this for a couple minutes on the way back.
And council, I'll just say it out loud. The part of the reason I was also making that suggestion is my next elections don't happen until June.
We very much appreciate that.
All right.
Your Honor.
Okay. Thank you, folks. Thank you, sir. Bond continue.
Thank you.
Thank you.
All right, fairly short hearing there. Let's go over to St. Joseph County and Judge Middleton. I believe he's doing sentencings this morning.
Morning is Laura Eileen Meisel. File number is 252291SD. The defendant is here with her lawyer, Mr. Nathan Taylor. Also present is Abby Stoll from the prosecuting attorney's office and Daniel Frazine, who drew this assignment for a screening report. I did have an opportunity to review everything this morning, actually last Friday and again this morning. Good morning, Mr. Taylor. What would you like me to know here?
Yes, thank you. She's 51 years old. She's married. Her and her husband have 4 adult children. One of them's here today. She's never been charged or arrested before.
That's not true.
What's that?
That's not true. When she was a kid, she had a A and B case back in the 90s when I was prosecutor, but
Okay, well, I'm sorry to mistake that then.
but it's a long time ago
Okay.
and it was a minor deal and but yeah, it wouldn't probably show up anywhere except my memory.
Okay, and so I thought I'd looked online and I hadn't seen anything out of that, but
It was under her maiden name.
that makes sense. She reports no alcohol since her arrest, which was in early November, so that's about 4.5 months ago. She has completed a substance abuse assessment. She completed the victim impact panel, which I have the certificate for. She's been seen Rena Castle for CBT. She's seen her 13 or 14 times. She has been attending AA. I have the updated AA sheets here with 36 total meetings.
Where are you doing your meetings?
At the Carver Center in Three Rivers and at the Presbyterian Church. in
Good
Three
for you.
Rivers.
As you probably know, a lot of my sobriety court folks are in the Carver Center regularly. There's some good people in there.
Yes.
Um,
Mary's my sponsor.
Who is?
Mary.
Mary's your sponsor too?
Yes,
Oh, she's busy.
she is.
Well, that's a good sponsor. Good for you. 36 of those you've had? All right, very good.
Since, I know they addressed this fence issue in the PSI, but there's some pictures that were taken on scene here. And I'll show them to the court, but the first one that's a little bit further away, it shows tire tracks. But it doesn't, they go close to the fence, but it doesn't appear that they hit the fence because there's some snow still on the fence. And then there's another picture here up close to the fence that shows that the snow has been knocked off. So clearly the snow was knocked off after the tire tracks got close to the fence. I can show those to the court if you want to see them.
Sure. I was trying to figure this out. She lives on 6th Avenue Road. This was over on Who took the pictures?
The officer.
Oh, well, I don't show any damage really, other than maybe just, but yeah, she was, and it was cold and snowy and, did you see these?
Yeah.
Okay.
Show me.
All right, thanks. Go ahead, Mr. Taylor.
So based on the 769.5 statute, the presumption of non-probation, I would ask that the court would only assess fines and costs. And considering the fact of how much she's already completed, I believe fines and costs would be appropriate. Based on the mitigating factors and not having damage to the fence, I would score her in the box A1. And I would ask that the court would impose the minimums of fines and costs and no jail with no further or no probation.
You guys are good at our guidelines, as good as anybody is, and there are only guidelines. They help us get a sense of it. Judge Welty actually created them maybe 30 years ago, but they do help us gauge the case along with other cases. The statutes have changed, and the one you just mentioned, that there's a presumption of no jail time in a drinking driving case if there is no accident. Daniel did the screening report, which is very good. She was pretty straight up about it. He did cut her some consideration because of the serious alcohol issues. He would have originally done a 24-month probation, but he was willing to do it in just 12, which could be done in 6. But you've already done many of the things that I would have directed you to do as a term of probation. Mr. Frazan, what else would you like me to know?
Well, I understand that there's for the presumption out there. I think with the driving, even though there wasn't a damage to the fence, going off the road like that, driving in someone else's yard, not being able to see it all out of her windshield because she didn't remove any of the snow, which easily could have ended up in her death or someone else's. And those are really terrible driving factors, as well as the extremely high BAC. I think it's real easy for the court to get around the presumption of fines and costs in this case. But I did give her credit, as the court mentioned, because she has taken this seriously. But I do think, in fairness to all those out there on the road and to what I think is a history of drinking, I think a term of probation, which, as the court mentioned, she could get done in 6 months. I think it's very fair to have her on there with some monitoring and just to make sure that she's doing well and help her reinforce that she should not be doing this kind of behavior going forward without taking away from what she's already done.
Well, she got a huge break having the matter reduced to impaired driving. So
and I do want to mention, I had missed a 145 to TRPD. The prosecutor showed me there was a request for that 145.
Okay. Abby, what would you like me to know?
I would just add, Your Honor, that our office did try to contact the homeowner. We didn't hear back from her, so we're not asking for restitution to repair the fence. But other than that, I agree with Mr. Frazan's report, and I would ask the court to follow that recommendation.
Ms. Meisel, what would you like me to know?
Your Honor, that was a wake-up call for me. And it opened my eyes to what had been going on and that I needed help. And I'm seriously getting that help because I do not want to go back to that time.
Well, I got the impression that reading between the lines that you left your house in anger. Like the people at your house were mad at you because you were drunk and then you left. Was there some sort of I don't want to call it I'll call it a heated discussion when you left your house?
No, my husband and I have been arguing all weekend and we just weren't talking. So I left. I can't explain it.
All right. You were going to a friend's on Broadway Street?
Yes, Your Honor.
So you weren't exactly going in the right direction. but you were very drunk. You were driving around like somebody in the bumper cars. The call came in. It took a while for the police to get there. You went off the road. You never brushed the snow off your window. You were an unguided missile. I'm really glad you didn't hit somebody else. Even with the officers, they asked you on a scale of 1 to 10, how drunk do you think I am? You said you were a 5. I think you're about an 8.5, and acknowledged drinking about a half a fifth of tequila. And that may be about right. People often minimize how much they drank, but that certainly could get you up to this 192 level. So Daniel has lots of experience as a probation agent. He made this report in good faith. You've done everything that I've asked you to do, essentially. You've gone to get an assessment impact panel. You're at AA. This accident occurred in November, which will tell you how crappy this season has been. It already had several inches of snow on the ground by November 9th. But you were dangerous. For all intents and purposes, you don't have any criminal record other than some I remember from when you were a kid. But that was 95 or 96. So we'll just assume you have none. There's a statute that Mr. Taylor addressed that says in a non-serious misdemeanor, there is a presumption that the judge will not order any jail time or probation. I don't have to like it, but that's what the law says. There's also a case called the People of Auburn Hills. I can't remember the defendant's name. I called the Auburn Hills case, which says there is a requirement that district judges sentence proportionally. I'm not really sure what that means. That proportionality is a big deal in circuit court, felonies with the guidelines. But I'm going to go with Daniel's assessment. I think you could use a short term of probation to ensure that you keep doing what you're doing. You've done it now because you had criminal charges hanging over your head. You don't have any charges pending, but I'd like to keep you on this path. I'm very pleased you've been plugged into AA. It's just down the street from your house. You're going to a couple of them. And you had done this, you had a long period of sobriety, but you never got arrested before. At least not for any of this, at least that we could find. But I am going to do a 12-month probation. I'm going to do 4 days jail credit 2, leaving 2 days to serve. And I'm going to defer those 2 days. You're not going to do any additional jail. I expect you to complete this probation in 6 months. I want you to keep doing everything you're doing. And if you do that, then I'll be confident that you're going to stay on that path. There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee. Did she have a private assessment?
Yes.
Yes, she did.
Or I'll cut that screening fee in half to $50. There is no attorney fee. $480 probation oversight fee, which could be reduced to $240, and $145 police reimbursement, and $32 for, oh, she's already done
the VIP.
She's all over it. Daniel's argument that there are reasons why this could have been determined to be a serious accident. You didn't do any damage to this fence, but you were driving with a very high blood alcohol. You hadn't taken the snow off your windshield. You couldn't see. You were driving very badly. And then when the officer got there, you were still driving very badly, bouncing off the curbs and that sort of thing. and you weren't on the way to Broadway. I don't know where you were going, and I don't know if you knew where you were going. So let's add that up. 300 plus 125 plus 50 plus 480 plus 145. That's it, $1,100. And if we take 240 off that, makes it 860. You did post a 2010% bond, so we have $180. The court keeps 10% of a 10% bond. $920 minus 240. $680 in the next 6 months. I think you can do that. All I really want you to do is continue with your substance abuse counseling assessment support groups. Drug and alcohol screens. You can't use any drugs or any alcohol while you're on this probation. You had a bond that says you can't do it. Now you have a probation. And I think this was a wake-up call for you, and I think you're taking it very seriously. But we're going to do 6 months worth of supervision. And I think you're gonna be all right. Do you feel better?
I do, Your Honor, yes,
You sleep better?
yes.
Yeah, I asked all my sobriety court people that once. Now, this was November, we're now in March, so about 4 months, that's a good start. If we get through 6 months, you'll be 10 months sober. And the likelihood of that continuing will just go from there. So I want you to go out with Daniel. I don't expect you're gonna do that 2 deferred jail days, because I think you're gonna do everything I asked you to do. But you go with Daniel, and I wish you good luck. I don't expect to see you anymore.
I get those photos back too, right?
Yeah, you can have them. They're there in the pack.
They're here.
Yeah.
Okay.
All right, Mr. Gibson, let's take your cases, and we'll start with Michael Marini. Which case are you here on, sir?
Gibson.
Okay, what's your
Oliver?
Mr. Oliver, you need to sit on the other side. You're on the attorney's side. We'll get to you here in just a minute. This is 252171, People versus Michael Franklin Marini. Mr. Marini is here. I met him at his arraignment. He's here with Paul Gibson. Also present is Abby Stoll from the prosecutor's office. The defendant is charged with careless discharge of a firearm. This matter was set for jury trial last Wednesday, March 18th. I was unable to do that, but Mr. Gibson was able to continue working on the case with his client, the prosecutor. Mr. Gibson, I understand we've got a plea agreement for this morning.
Yes, Your Honor.
What is that?
It's my understanding the defendant will be pleading as charged. And there won't be any, the prosecuting attorney had indicated that they were considering reauthorizing different charges. So it's my understanding by accepting this plea that this will resolve the matter.
Is that correct, Ms. Stoll?
That's correct, Your Honor.
Well, let's talk about this. The complaint, I thought I copied it, but I guess I didn't, alleges that on October 18th at your apartment that you discharged a firearm carelessly. This is a very poor statute. It's an old one. It's called discharge of a firearm with damage over $50. It's a misdemeanor punishable by up to a year in jail and a fine of up to $5,000. It's a poor statute because it combines two standards in the same charge. Did because of carelessness, recklessness, or negligence, but not willfully and wantonly cause or allow a pistol under his control to discharge and injure property of Annalisa Woolams in excess of $50. Careless and reckless are not the same thing. Carelessness is a low standard of failure to take due care, and recklessness is willful and wanton conduct. So the statute is full of contradictions, but if at least careless discharge qualifies. Do you understand the charge, Mr. Marini?
Yes, sir.
You've signed the waiver of your advice of rights, and you're willing to enter a plea at this time.
Yes, sir.
Prosecutors agreed not to recharge this as a felony charge. There are some other charges about discharging a firearm in a building or other things that might fit these facts. But with this plea, this would resolve the matter. Is that your understanding, Ms. Stoll?
That is, Your Honor.
All right. Mr. Marini, did anybody promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
All right. Now, in my review of the booking sheet, it sounds like you were doing like ninja stuff in there and your gun went off. Tell me what happened.
Oh, I, the whole. It wasn't really anything. I would, like you explained reckless. I was handed a firearm that wasn't mine, that I was told was clear. And the person that handed me the firearm and said it was clear, I did trust at the time.
Oh, I thought it was your gun.
No, sir.
I misunderstood, but I thought you were doing this kind of stuff with it. You talking to me kind of thing?
No.
All right. All right, well, tell me what happened.
I was handed the firearm by Annalise. She said it was clear and everything. I have been woken up by her. We have been arguing for the last 2 days.
Now, she is the mother of your child?
No.
But
She's
your
just a girlfriend.
All right.
Things had been rocky between the two of us the last couple weeks, and I was trying to find a place to move to because I'm from Indiana, and I was just trying to find a place to move out and keep my job at IAC and everything. And it was a Saturday morning. She woke me up, and she was planning on going shooting with one of her friends. I don't go with her when she does that. She was like just talking. She had a couple of her guns out already. It was weird to wake up to that. Kind of disconcerting, but then she handed me a firearm. She's like, here, it's cleared. I'm not even sure what she said to me exactly, but she's like, it's cleared, here, hold this. And I'm just barely awake. I had just kicked my feet onto the floor, off the bed, and she hands me the pistol, and the slide was already back. I didn't check it. I assumed it was cleared, like she said. I let the slide rack forward, and it went off. But it was not like aiming all crazy or anything, because I had it pointed away from both of us toward the floor and angled down toward the floor a little bit at the wall, away from everyone. And when that slide kicked forward, she still had, somehow there's still a round in it.
All right, so this was a Glock 9?
It wasn't a Glock, sir. It was, I believe, a Palmetto State Armory was the name of it. It was like a Glock clone. It looked like a Glock, yes, sir.
Okay. And you had actually dumped the magazine out of it?
She handed me, I was just awake. She said it was clear. I assumed the magazine was already out. I think there was still one in the chamber possibly.
Well, what she says, that you guys had been arguing. They were just out there the day before for a domestic assault. Then she said Michael was doing military maneuvers with a handgun.
Not at all.
He then pointed the gun at the wall and shot it. She advised that he racked the gun slide back multiple times, was dropping the mag and putting it back into the gun multiple times as well. Michael's in the military and has experience with guns. He has PTSD and was not doing well. And then you shot a hole in the wall in the room the child was in the next room. So her version of what you were doing, this gun, and yours don't match.
Absolutely.
Although what you told me is enough for the plea. Then you said he believed the gun was unloaded because he had dropped the magazine. I asked him if he checked the slide. He said he did not. So you told the police you dropped the magazine. Abigail, what's your take here?
I believe that's a sufficient factual basis, Your Honor.
All right, you agree, Mr. Gibson?
Yes, Your Honor.
And also, Your Honor, from the time the incident happened to the time she called the police, it's 2 days later. I don't know why he would do that and then say someone else did all these things and make up this huge story. If that happened right away, you would think that was, because I was the one after it
Well,
happened.
tell me, what's the relationship between you and Annalise Willems at this point?
Oh, nothing, none. I have no contact with her. She has no contact order on me. I have nothing to do with her, sir.
All right, Mr. Gibson, what would you like me to know?
Well, I believe that this situation was an accident. And so you could say that it was a result of carelessness or negligence, but I don't think that, as you said, the dual nature of the statute, I don't believe that anything that happened was reckless or done willfully or wantonly. So, the defendant, he does have some prior things on his criminal record, but it's my understanding that those are in his past. And so I would ask the court to consider fines and costs, potentially if there's additional factors the court wants to consider, then I would ask the court to consider community service or probation in lieu of any jail time. Thank you.
Your Honor, can I say one more thing?
Yes.
I was very close with Annalise's daughter, Catherine, like very close with her. And the whole domestic thing that happened the day before, her mom and I were arguing, and Catherine, she wanted to go for a walk, so she went for a walk and was crying, and a neighbor seen her crying and asked what happened, and she said her mom and her mom's boyfriend were arguing, and she just didn't want us to argue anymore.
How old is this child?
She's 14 now.
All right.
And she just didn't want to see her mom argue with me anymore because I was the one that was trying to bring some balance to the home, because her mom was, as I found out, was, needed some mental help and stuff, and probably a little counseling and whatnot. And Catherine was just in a very bad place. And I have a daughter her age, and I saw my daughter and her, and I took to Catherine very quickly, and her and my daughter were close, and it was just, I just wanted the court to know that, like, regardless of not having any contact or anything with you and Annalise, I feel terrible for what happened with her daughter, and I just want to know her daughter's still okay. That's all. Because when I left, her daughter continued to text me and miss me and everything like that. I couldn't respond because we had no contact.
Where do you live now?
I live in 419. Oh yeah, it's 920 Hawkins Street. I'm sorry, I'm new to Three Rivers still, from Columbia City originally. And I've been in Warsaw the last 2 weeks, sir. I've had a family member got really, really sick. and I've been watching their kids.
What do you do? Do you work someplace?
I'm on unemployment. When I got laid off from my AC, I'm on unemployment still. So I have an income coming in. And then with the storm that came through also, sir, it really tore my house up. Like I have 6 windows that are broken that I can't afford to fix. Part of my roof is messed up. We got tarps up there. I literally have a kiddie pool in my back room catching the water right now until I can afford to fix my roof. And then that second.
Hoffman Street got hit?
Yes, well, my house is old and kind of ratty as is, and it just, that wind kind of just, what was already messed up my roof really messed it up.
All right, have you been in contact with United Way and the other people that have got money to
I
do
have a
this?
church willing to help me, yes, sir. It's just taking some time.
I didn't think the storm hit Hoffman Street, but there was plenty of damage.
Yeah, there's a lot of wind damage around, sir, around the rivers, more than what you'd think.
All right. Ms. Stoll, what's your thought here?
Your Honor, I would just ask the court to impose the typical sentence for careless discharge.
Well, the facts are in dispute, but what he told me and what I have as a factual basis is carelessness. Is there a restitution request?
We have not received one.
All right, or any other victim input?
No, Your Honor.
Yeah, this is listed as having occurred on 10/20. It actually occurred on 10/18. 2 days passed before she reported it. He got arrested on the 20th and then bonded out later. In order, 2 days jail credit, 2 days. A $100 fine, $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee. I'll reserve on restitution. This wasn't her house. This was an apartment along the river there.
Yes, sir.
Was this at Edgewater? Or the little apartments across from the dairy bar?
It's the apartments right across from the dam by the river.
All right, well, those are they really got torn up by the
Yes,
tornado.
I'm not, and then where Paul's Pantry is down the road,
Yes.
where that's Hoffman, you go right past the high school and middle school. My house is on right around the curb by the VFW right there.
Yeah.
It tore up the cemetery back there and everything.
Oh, it greatly tore up the cemetery. 9/20. Is it past the bridge?
Yes, sir.
Okay.
Bridge.
Well, there's the bridge, the Hoffman Street Bridge.
Oh, yes, yes, sir, yes, sir.
All right, it's on the other. There's only 3 houses there.
Yeah, there's like a CNC shop, my house, and then those townhouse complexes right
Okay.
there on the left
All
side.
right. You're in what was the old Jacob's house? I think. Anyway, let's add this up. 125 plus 100 plus 150 is 375. The firearm is forfeited. It'll be destroyed. I don't even know whose it was. One person said it was yours and one person said it was hers. It wasn't registered. Firearm is forfeited to be destroyed. I'll give you 60 days to pay that $375. Make it due by May 29. you need more time, come see me. This probably would not have been very hard for a jury to vote to convict on this under the careless standard. So I'm glad we were able to resolve this without taking up a jury day. Mr. Marini, you're good to go.
Was that John?
You're good to go.
Thank you, sir.
Alrighty, friends, let's go back to Judge Elmore. He has a new contestant, I believe, for another sentencing.
May be seated. Also before the court this morning is Mr. Sean Van Atwell. He is the agent from the Department of Corrections who prepared today's pre-sentence investigation report. Second.
That's just for clarification. I'm covering.
You're covering for Lindsay Simmons. I'm sorry. I just saw that. Thank you. I'm sorry. Is it Maz? Maze?
Mas, M-A-S.
Oh, yeah. Thank you. Thank you. All right. Let me take a quick look, see if I had any corrections or made any notes. All right. I did not, other than my own notes reminding me of our discussions that we had about this plea before I took it on the record. I think we discussed it in chambers. All right, Mr. Carnes, how about you? Any amendments, corrections, or objections to make to the contents of the report? No. Ms. Moss, same question?
No.
Thank you. All right. And we have, no, the sentencing date is correct. I just wanted to make sure it wasn't one of the cases we adjourned from last week due to the weather. All right, Mr. Carnes, victim impact.
Your Honor, I'd like to say before I read this, Peyton has some words in here that he wrote verbatim what his dad said. I'm going to abbreviate the word.
Okay, I'm sure they're kind of words I can figure out.
Yes.
All right, so before us is Ms. Crick from the prosecutor's office as the victim advocate. And go ahead, ma'am.
Okay, Your Honor. It has now been 5 months since the assault, and during this time of no contact with my father, I have still lived with fear, panic, and a constant sense of being on edge. Although the immediate shock has lessened with time, the lasting impact of what happened has not disappeared. I felt in my neck that day was real, but what has stayed with me most is the fear and trauma that continue to affect me daily. My father has shown himself to be unpredictable, explosive, and dangerous. The things he said to me, such as "I'm going to effing kill you," and "I would have broken your neck if it was just you and I," are words I still remember clearly. They are the reason I continue to struggle with feeling safe, especially at night when those threats replay in my mind. While I'm working to move forward, the fear he has created has not gone away. I believe it is necessary for the no contact order to remain in place until I turn 18, so I can continue to heal without the worry of being forced into contact with him again. Sincerely, Dayton Kohlberger.
Thank you. Mr. Carnes, anything else as far as a victim impact statement?
No.
All right, thank you very much. Any allocution?
Yes, Your Honor, thank you. I did meet with Peyton early on in this case, and that victim impact statement does kind of sum up the feelings I got during our meeting. They did review photos in this file showing red marks consistent with Peyton's description of what happened. This is a very concerning incident. However, when I met with Peyton as well, the other thing he told me is I don't want my dad to go to jail, and I just don't want to see him for a while. So we came up with this Killebrew agreement for DV with 4A, 18 months probation with a no contact order staying in place throughout that period of probation. I would ask the court to follow the agreement. Thank you.
Mr. Moss?
Thank you, Your Honor.
Yes, ma'am.
Your Honor, again, there is a killabrew here, but I would like just to give you a little bit of background of Mr. Howard. He has, I believe he has a juvenile something from many years ago, but otherwise has no criminal history, nothing violent. I think something that stood out to me when reviewing the discovery was everyone involved said, like, this is not normal, this is atypical, this is not someone who has regularly is explosive or violent in any way. So I think that is an important note. Here, Mr. Howard is taking responsibility. He immediately enrolled in counseling. He's been in weekly counseling since December, taking that seriously. He has absolutely not violated his no contact in any way. This matter has been pending for quite some time. And in addition, he has a partner, he has another child, he is a caring father. He built a business, a very successful business locally. I mean, this is a unfortunate situation that he's here taking responsibility for, and will continue to honor the no contact and give his son the space he needs to heal. And if and when in the future they can have some sort of relationship, that will be, you know, up to his son. I would say that, like any criminal case that comes before the court, you know, I could contest different facts that have been presented in the PSI, but I don't, with this killabrew taking advantage of this plea offer, I don't find it to be necessary at this juncture. So I would ask the court to follow the killabrew, allow and to do the healing that he needs, allow Mitch to continue supporting his family, his young child, continue his counseling, and just ensure that this situation never happens again, which I can tell this court that it will not. So thank you.
All right, Mr. Howard, you have the right to make a statement if you choose to do so. Is there anything you wish to say at this time?
No, Your Honor, I agree with everything stated by my attorney. I just wanted to reiterate that I have taken responsibility for the reason that I'm standing here today, and I've been proactive in my approach to finding a resolve.
All right. I don't want anybody to stand up, but maybe I could just have a head nod. Which one is Peyton?
He's
Not here? Okay.
No, Your Honor.
Now, the reasons I wanted to know, I just wanted to make sure the young man knew what 4A was. And I trust that the parents here do. It means that if he's successful with the period of probation, the offense would be dismissed. Is the mother here? No?
No, I did discuss 4A with both of them.
Okay, as long as they do.
Yep.
Well, this is an issue, and I understand completely why Judge Wiggins didn't want to accept the plea at this charge. Wherever it was, I don't know, but it wasn't going to follow the agreement. I don't remember exactly how you all said it. I don't blame him. The description here of the event is quite frightening, and I'm going to suspect that the young man who's 14 stands in the shadow of the father who's got to be 6'3", I'm going to guess, and is a U.S. Coast Guard, or was U.S. Coast Guard member, and was a rescue diver apparently. Obviously much bigger. And the words here were just terrible. The conduct was absolutely embarrassing. Now, every father, husband, person, mom, dad, whatever, we all make mistakes, in controlling our actions and overcoming our errors is our responsibility. You've now revealed to your son that you're not perfect, and he will never forever know it. And it's going to be up to you to repair that relationship. And it's not his. It's not his burden. His burden is to figure out how to grow up and be a good young man based upon the examples presented to him. But it's your job to repair the relationship when he's ready to entertain it. So when I spoke with counsel in chambers about this a couple months ago, yeah, I was hesitant, but it was only because of the support of the victim and the other parents that I was even willing to entertain it. However, if there's any violations with our terms and conditions of the 4A, that will more than happily put them in jail. Right? And based upon the conduct here, it would be up to 93 days. I would expect you'd get to 93 days. And you'll lose the 4A. I understand you've got businesses and maybe in other parts of your life you've been very successful. That's all right. None of us are perfect in everything we do. And we often fail those relationships with the people with whom we are the closest and should be the closest and always put first, but we fail. Now is the opportunity to show Peyton how a father, how a husband takes it on the chin and then sets the right example. So I hope that's what follows. All right, the court assesses a $68 state minimum fee, $75 crime victims' right fund fee. The court assesses a $200 court cost as the case is processed through the district court up to here. The court is going to set a $500 fine. Ms. Moss was retained, so there's obviously no fee there. Well, was there a DNA fee here apparently at some time? The domestic, well, it wasn't charged as domestic violence initially, so there probably wouldn't have been. So there is no DNA fee to take there.
I don't know.
Nope. $30 is supervision, and I'll cover that in just a moment. $60 if there's any electronic monitoring. The court assesses the 18 months of probation that is pursuant to 4A, which is a subparagraph for domestic violence first-time offenders. And if the defendant is successful with the completion of that period, then the charge will be dismissed pursuant to the statute and the pretrial agreement. The court now has to turn here and terms and conditions of probation. Oh, I need to cover the 2 days in jail with the 2 days of credit.
The state minimum should be 50 is all correct.
Yeah, I thought I said that.
68.
Oh, well, I circled 50, so you should have known what I meant.
Perfect.
Thank you. The terms and conditions of the 4A are on CFJ 145, pages 2 and 3 of the report. I find that those terms and conditions are well suited for rehabilitative purposes. Well, I don't think there was any issue here of drugs, and I don't know all the factors here, but I find that because of the volatility, and there were some statements here that said it was abnormal or out of conduct, or I'm sorry, out of character. That gives me some concern as to what it's for. And if there's any issues for anger, I'm afraid that any substance, even alcohol, could add to it. Therefore, again, I find the terms and conditions well suited. All right, Mr. Bennett, have I missed anything in this file? Mr. Carnes, anything else?
No, Your Honor.
And Ms. Moss, anything else?
No.
All right, so Mr. Howard, big step back, but let's take some big steps forward. Any questions about what we've done today and what your objectives here are?
No, Your Honor, I appreciate your time.
Yeah, now I know I was sounding a little bit, well, probably not mean or harsh, but talking about the potentials of jail. But what the message is there is children, kids, are you still in the service? You're not in service anymore, are you? No, no, all right. Well, still, as a leader, business owner, husband, father, that's the example that you set that you have to worry about next. That's your objective. All right. Keep your eyes on the front of the mission. We are adjourned.
Thank you.
Thank you.
Good morning once again, friends. TCF Live on a Monday. My name is Dan, your fearless leader through our journey through Courtlandia this morning. Let's go to Judge DeSanto, Judge Mom. Say good morning there.
Step up, state your name. Clarence Stewart. Thank you.
All right, thank you. Today is the date scheduled for sentencing on this matter on your client's plea to an amended charge of operating while visibly impaired, as well. The operating while intoxicated and the open intox were both dismissed by way of resolution between counsel and counsel. Do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, I did go over this carefully with Mr. Stewart. He indicates to me that everything in it is factually accurate without giving any corrections.
We also reviewed the recommendation. It seems in line with justice and the statutes that are applicable. I believe Mr. Stewart may have a few words he'd like to address the court. Is that correct?
Yes.
Okay,
Just apologies for disrespecting the law.
okay, I can appreciate that, sir. However, to that end, what have you done with your 3 warrants?
I'm in the process of getting all that taken care of.
Okay, what does in the process mean?
It's just tickets I have to take care of.
Well, 2 of those are, the other one is a warrant for operating while intoxicated out of the 46th District Court that you did not appear for. The warrant was issued January 14th of 2026.
To be honest,
Yes, so just a couple months ago.
it's not the right person. That's not me.
No,
No,
you were not arrested in Southfield?
no.
And I have no information about that either. The report from the probation department lists some things that are 15 years old.
Well, yes, there's that too. Let me see here. Yes, this is your date of birth, your height and weight. Yeah,
Southfield?
Southfield.
This year.
Driving under influence of alcohol. Well, let me see here. The warrant was issued January 14th of 2026. Yeah, so it's you. The date of the warrant was January 14th of 2026. I don't know when the offense is alleged to have occurred. That doesn't. That's not specified on here. Or if it is, I'm missing how to read it. Oh, hold on. Well, one's from July 7th of 2010. Same date of birth, same height and weight. So yes, sir.
2010.
Well, you have one driving while license suspended from 2010. You have another driving while, and that's also from Southfield. And driving a license not valid, that warrant's out of the 19th District Court in Dearborn from July of 07. And then you may even have one out of Redford from November of 24, but we're going to confirm the warrant out of Southfield, sir, so we can determine whether or not that's you. How'd you get here today, sir?
Bro,
What's the status of your license?
valid,
How long has it been valid?
over a year.
Sir, your level of the 0.253, that's high. Very high. The court will be submitting to random test while on bond and you have not had any positive tests. The court will also note that after hearing from counsel, well, actually what we're going to do before we proceed, I want to see if this warrant is still valid and if it is your client's. because that may affect what I do as far as if I'm ordering probation, and if so, if I'm adopting the recommendation that's been put forth or a different time frame. So we're just going to check on this and then we'll recall. Okay. All right. Okay, thank you. On the record in the matter of the city of Wyandotte, Stephen Marito, 251570.
Your Honor, we saw that. Defendant, Mr. Rachel, please step forward. And have your hands in your pockets. If you're name to the judge, speak clearly, sir. Stephen Marito.
All right, good morning, and thank you for being in person. I know that you've been on Zoom for the other matters. And so are you picking them up, Ally?
Yeah.
Okay. And so counsel, today's the date scheduled for sentencing on your client's plea to the charge of possession of controlled substance. And did you have an opportunity to review the report and recommendation with your client?
Yes, it's fair, it's accurate, nothing further to add with the exception because he lives and works primarily in Charlotte, North Carolina, that should permit community service. He's been tested, and he's done well with the court here, and he'll take care of whatever probation matters are necessary because you have family here and you have a residence here too, is that correct?
Yes.
And Judge, he's going to need a moment with probation because he and I had this week of panic. We're on the runway, his dropped his cell phone and it got smashed and he's not replaced his cell phone yet. So he's gonna have to find some way to keep in contact. I hope when you're in Detroit today, you get a cell phone, you get back on the road.
I plan to.
Ooh.
I know, he's in a risky business. Now, and I know you wear earmuffs all the time. You're gonna have to speak up because I can't hear you either.
I apologize. Yes.
That's okay.
Nothing else to add, Judge.
All right, so you've been participating in random testing, correct?
Yes.
And I don't have any indication that you have tested anything other than negative. And so you have to be better than this.
Yes.
You are better than this, so you need to stop this. If you feel as though you need extra motivation to stay alert, awake, or whatever, right? Maybe try some extra coffee.
Yes, ma'am.
Not cocaine. The court will also note that after hearing from counsel and Mr. Marito, that in reviewing the report and the recommendation, there is reasonable grounds to depart from MCL 769.5. The court the court will also find that the following sentence is in the best interest of justice as reasonable proportion to the seriousness of the matter, taking into account the circumstances surrounding Mr. Marito and the legislative guidelines. The court will note that one correction was that my first name was spelled wrong. There's a Z, not an S, but in any event.
Talk to somebody about that, Judge.
Yes, and so the court will order the following: 18 months probation. You're eligible for early discharge. You're also eligible under 155.001. As indicate, as put forth by the plea between the parties. You're not to violate any criminal law of any unit of government. You're not to leave the state of North Carolina without consent of the court, since that's where your home base is, so to speak, for work purposes. If you intend to travel back this way, you have to confirm and communicate with your probation officer.
You back to Michigan?
Yes.
Okay.
Since North Carolina is your home base, right?
Yes.
I mean, you're pretty much residing there and coming back to visit.
Yes.
Okay. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing, which you're going to continue. The rehabilitative goal for that condition is so the court can continue to monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you have assistance in providing coping mechanisms to maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. And the court's going to order you to participate in fan meetings. I'm pretty sure there's a chapter in North Carolina. If there's not, we can revisit that.
Okay.
They meet on Thursdays.
Or they're-
Judge,
Well, the downriver one does. The Western Wayne meets Mondays, but there may be virtual ones. That you may be able to attend as well. Okay. The rehabilitative goal for that condition is so you can have additional support system in maintaining sobriety and having additional recovery resources. The court's going to also order community service. The court's going to order 50 hours of community service, not Wyandotte Indians, because that's something that you've already been doing, right? There's something over and above so that you can further develop life skills and give back to the community. Any questions regarding those conditions?
no, ma'am. I just have one, Your Honor, because he still has family here and still coaches when he's not working here. Can you advise probation, maybe they can work up the weekend pass to come home? So he's not every week asking for permission to leave North Carolina to come back here. I mean, it's a dual residency.
I'm sorry, what you're,
I would just, would probation consider a blanket weekend pass to come here, do his family functions here, instead of calling every week to ask for permission to leave North Carolina and come home?
well, we have to know where your client's at. So, because if he's called for testing, right, and
That's right.
then so, yes, that,
Just call her.
the communication just has to be there.
Yes, ma'am,
Right.
communicate with her.
Okay. All right. Okay, and so as to the fines and costs, the court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee, $50 a month at 18 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,725. You did post a bond, which can be applied. I'm going to have you set up your payment plan with probation. Okay?
Thank you, Your Honor.
Any questions?
Nothing, ma'am. Appreciate your indulgence. Thank you, Judge.
All right, good luck to you, sir. Oh, as I've indicated, you are eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made good faith effort toward making full payment.
Okay.
Okay?
Thank you very
All
much.
right, thank you.
Thank
Have
you,
a good
Doc.
day. Let's go off the record. Mr. Zelnat, can you send Mr. DeBloyan, please?
Yes, I will.
Thank you.
All right, we'll check back in probably at some point with Judge DeSanto, but let's go back to Judge West.
Happens if you're not is your bond gets forfeited and raised. I'm going to recall the bond forfeiture. Mr. Samuel has said that you have hired him or intend to, so I'm going to reset your case. Make sure you stay in touch with Mr. Samuel and your bondsman. They'll let you know when you need to. Okay. All right, you're free to go. Thank you, Mr. Samuel.
Thank you.
Charles Beard. Are you wearing shorts?
Yes, ma'am. I just know I was trying to get a ride and I had right camera paid and he's banned from the courtroom, so I'm trying to find a lawyer, find a new lawyer.
You're trying to what?
Find a new lawyer. I have right camera paid and I guess he's not allowed here.
He's here today.
He is here? What's his name now?
Charles Beard. What does any of that have, sir? What does any of that have to do with the fact that you showed up in shorts to court?
I was coming from the house trying to just make it.
Okay, so it's felony court. You need to dress like you want someone to take you seriously on a felony.
Yes,
Does that
ma'am. I
make
just got
sense?
the job at the maintenance at the motel and it's just the only job they have me right now.
Okay, well, I'm glad you did that. Make sure, number one, make sure you're on time. Make sure you dress appropriately, okay? Shorts aren't allowed. And so what I'm going to do, Mr. Beard, is your intention to hire Mr. Kimler?
Yes, ma'am.
So let me go through. This is your initial appearance and cause number 26 DCCR 0138. And in that case, you're charged with the state jail felony offense of unauthorized use of a vehicle. And that's from December 16th of 2025. And so what I'm going to do, since you've made bond, is reset your case about 30 days to give you some time to get Mr. Kimler hired or someone else. If you get them hired, whoever, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If for some reason you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you go to jail. Do you understand?
I also had them on two, misdemeanor.
Okay.
So you can pay for that first before this, so then I was understanding how. it
Gotcha.
works.
We'll visit with him about all of that. I will recall the bond forfeiture as well. If you step in front of the clerk, she'll give you a reset notice.
Thank you very much.
Yes, sir. Alexandra De Leon. Good morning. Are you Alexandra De Leon? Miss De Leon, it's very important that you're here on time. Do you understand? Where were you this morning?
At the wrong courthouse.
Okay, so I'm going to recall the bond forfeiture. This is your initial appearance in cause number 26 DCCR 0143. You're charged with the second-degree felony offense of assault on a peace officer. Stand up straight. Don't lean on. You're charged with assault on a peace officer, and that's from December 28th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Okay.
So what I'm going to do, Ms. De Leon, is reset your case. Take a look at this. See, before I go, if I test you this morning, are you gonna have anything in your system? All right, let's double check that. Have a seat in the jury box.
Judge, this second gentleman, were we testing him for the one with tattoos?
No, he's free to go.
Okay. You can go, buddy.
Yeah. Yes, sir. Deanna Paul, let's see, I took care of that one, right? Deanna Paul already. Who else do I have up there? Just the. Maybe so. Let me see. Christy Johnson. Good job. Ms. Johnson, it's very important that you're here on time to court.
Yes, ma'am. I was 8 minutes.
I'm sorry.
I was 8 minutes behind. I'm still there.
I understand. You can see it's very busy, so I call the cases and you get a bond forfeiture if you're not here. I'm going to recall that bond forfeiture. This is your initial appearance. In clause number 25 DCCR 1782. You're charged with the third-degree felony offense of harassment of a public servant from October 29th of 2025. Since you've made bond in your case, have you had an opportunity to hire a lawyer?
Yeah, I'm trying to hire a good one because it's a false report and I was reporting this evening. His badge number is 363.
That's okay. You don't have to tell me all that. So here's what
I'm trying to get a good lawyer. The one I really use, he said that you're a tough one and it's gonna be hard for us to get it dismissed and it was done a Boudreaux. So I was trying to go.
Well, whatever happens between you and the district attorney's office, that's not up to me if a case gets dismissed or not. So I'm going to reset your case for about 30 days to give you some time to hire someone.
Okay.
If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you talked to when you come back, so I know you're trying, and then we'll discuss your options. And if you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Well,
Do you
I
understand?
To 3, so.
Well, the point of it is to hire someone, not just to get the 3 names. I want you to hire someone before the next court date, but you'll see when you're talking to them that they all have different plans and things like that. So if you can't get someone hired, bring me the names of who you've talked to, okay?
Okay.
Step in front of the clerk, she'll give you a reset notice. Okay. Oh, yeah, okay, so we need to, Kevin Scott here. Mr. Scott, Mr. Burbank is still in trial, next door from a trial that started last week. And so I'm going to reset your case for a couple of weeks or so. Make sure you stay in touch with your bondsman and Mr. Burbank, and they'll let you know when to be back. You're free to go, sir. Mr. All right, Mr. Simon, so you tested negative, which is great. And so what I'm going to do, Mr. Simon, is reset both of your cases for about 30 days to give you some time to try to hire someone.
You give me a little.
Everybody gets 30 days. And so if you don't get someone hired before the 30 days, then bring me information about who you've talked to. Bring me information about where you've attempted to get a job. If you get a job, bring me a pay stub.
Like, applications or?
Yes,
I mean,
whatever you can do to show me
because most of
that
them
you're
are online now.
then print it out, screenshot it, do whatever you need to so that you can bring me proof of what you're doing. Okay, step in front of the clerk, please. Mr. Paget.
Yeah.
I guess I do. Mr. Paget, you have Kenneth Spears?
I'll charge him.
I'm ready.
Okay, okay. Yeah.
Morning. Mr. Coleman, are you getting as much,
Yes, Judge.
you would think something like that's never happened before.
Smart. Focus on what I need to focus on.
I agree. Same here.
Pull that. Oh, sorry, Tom. That's my fault, you know.
It's okay. Good morning, sir. Are you Kenneth Spears? And Mr. Paget, will your client waive the formal reading of the indictment?
Yes, sure.
All right, and we're going on the full indictment.
Yes, Judge. That's my understanding, Your Honor.
Mr. Spears, in cause number 25 DCCR 1425, you're charged with the state jail felony offense of fraudulent use or possession of credit or debit cards from July 17th of 2025. Your indictment alleges that you were previously convicted of attempted forgery by possession, a state jail felony, May 1st of 2000. Also, well, it looks like on that same date, 3 offenses of attempted forgery by possession. And then after those were final, you were convicted of possession of a controlled substance, a state jail felony, March 22nd of 2006. 2 cases of possession of a controlled substance on that same date. And then after that was final, or those were final, you were convicted of the state jail felony offense of evading arrest or detention, January 6th of 2014. And how do you plead to the charge of fraudulent use or possession of a credit or debit card? I'm sorry. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? Speak up, please.
Yes,
And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget? Do you fully understand them? And it looks like there is not agreement, which means you're leaving your punishment up to the court. And the range of punishment for this offense with those prior convictions would be that of a 3rd-degree felony, which is between 2 years and up to 10 years. And what that means is that I can sentence you anywhere in that range of punishment. You have every right to have a jury come in and decide two things. One, if you're guilty or not, and then the second is you could leave your punishment up to that jury. If we go forward, you'll be waiving that. Is that what you want to do? And so there is no agreement. So he does have right to appeal, but you guys have signed the post-conviction
We have
waivers.
changed things a few times. It's correct. I need to take it back and
Judge, state has no objection to you.
I'll just mark for the
Modify.
yes, we have no
So
objection.
because there's no agreement, you do have some rights to appeal depending on what happens and you
And that is how
understand that as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please.
Yes, ma'am.
And it looks like the state is recommending, and of course, we'll see when the pre-sentence report comes back, a 5-year term. You are asking through your attorney for a deferred probation. Is that correct? State tenders number 1.
No objections to stage 1, Your Honor.
It's admitted. Is there any evidence that Mr. Spears is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, this case, your history, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Paget and he will present it to me on your behalf when we come back. All right. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right over there. All right. We'll see you back at sentencing.
Thank you, Your
you.
Honor.
Thanks, Judge.
TCF Live friends entering hour 4 now. So let's do more court. Let's go down to Florida. Brantley Clark. Haven't seen him in a while. Let's see what's going on.
Your Honor, this is Zinnia Edwards, case number 23-2451, which is a VOP, and 26-359, which is a new law violation. As to both, she withdraws her previously entered plea of not guilty. In case number 2451, she'll enter admission of violation of probation based on a burglary of a conveyance, a 3rd-degree felony punishable by up to 5 years in the Department of Corrections. In case number 26-359, she's going to enter a plea of no contest to count 2, DV battery, a 1st-degree misdemeanor punishable by up to 1 year in the county jail. Pursuant to negotiation with the state, she'll be adjudicated guilty, including the underlying felony and the VOP. Her probation will be extended 48 months. She'll pay court costs and fines. She has 48 days jail credit, 50 hours community service work in addition to what she already had, $20 a month cost of supervision. Department of Motor Vehicles may apply additional penalties. Time served on the misdemeanor, DNA sample, mental health evaluation and counseling as recommended. No contact, peaceful contact with the victim for time sharing. The remaining count is consolidated. Defendant must complete the BIP program.
That's the agreement with the state?
It is, Your Honor.
Yes.
All right. Ms. Edwards, you can lower your hand, ma'am, and state your name.
Zania Edwards.
Ms. Edwards, you heard the announcement of Ms. McCarthy, is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything different?
No.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand the terms and conditions of it?
No, sir.
I've been handed a plea waiver consent form. There's the front. On the back, it's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over with Ms. McCarthy, your violation of probation and your new charge?
Yes, sir.
Have you had sufficient time to speak with Ms. McCarthy about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering the plea, you're waiving your right to have an evidentiary hearing in the violation of probation, and you're waiving your right to have a trial on the new charge?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes.
Are you doing this of your own free will?
Yes, sir.
Ms. Edwards, do you feel this plea is in your best interest?
Yes, sir.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
I'll accept the stipulation and we'll find there's a prima facie case and we'll find that Ms. Edwards' plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. He's adjudicated guilty on, this is 26-354 of the domestic violence battery. Sentenced to the time she served in the Bay County Jail, giving credit for that time. On case number 23, CF 2951, I am going to accept her admission. Her probation is modified as follows. She's adjudicated guilty of burglary of a conveyance. Her probation is extended 48 months from the original sentence date. She must complete a batterer's intervention program as a special condition of her probation. She may have peaceful contact with the alleged victim or with the victim in the domestic violence for time sharing. All other conditions that were imposed are reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. Ms. Edwards, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, and you can afford one may be appointed to represent you at no charge. Good luck to you. You need to step over and be fingerprinted on that battery and burglary. And Ms. McCarthy, that's yours.
Fine, thank you.
Yes, ma'am.
Mark, can you hear me? Is me welcome it? Your Honor, her case number is 26-280, and we have a felony PTI, so we just need a tracking date for her.
All right, I'm gonna set it for April 23rd at 1:30 to allow her to set an appointment with the Department of Probation and go over the contract. And then I am going to release her from her bond, and she'll be on her own release on her own recognizance. And she'll step over and speak with the probation officer.
Brandon Whitaker. Going to be entering a no contest plea to one count of false report of a bomb. Be adjudicated guilty, sentenced to 60 months of probation. His court costs and fines will be $1,028. Do 100 hours of restitution, $20 a month cost supervision, drug and alcohol evaluation and counseling as recommended. Zero tolerance to use of controlled substances, random urinalysis at defendant's expense. Adjudicated, there's no misdemeanors or anything, right? All right. Submit to a DNA sample, forfeit any seized items. We stipulate there's a factual basis for purposes of the plea. And mental health evaluation and counseling as recommended. No contact with any victims.
That's the agreement with the state.
Yes, ma'am.
All right, Mr. Whitaker, you can lower your hand, sir, and state your name.
My name is Brandon Dion Whitaker.
You put your hand down. Mr. Whitaker, you heard the announcement of Mr. Killian, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front, on the back of the document is a signature of the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read that agreement?
Yes, sir.
You had the opportunity to go over your case with Mr. Killian?
Yes, sir.
Have you had sufficient time to speak with Mr. Killian about your case?
Yes, sir, I have.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir, I am.
Do you understand that entering the plea, you're waiving your right to go to trial?
Yes, sir, I do.
You're waiving your right to have your attorney cross-examine the state's witnesses?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
Waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
Waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Whitaker, do you feel this plea is in your best interest?
Yes, sir.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir, I do.
I'll accept the stipulation. I'll find as a prima facie case. I'm gonna find that Mr. Whitaker's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He's adjudicated guilty of false report of a bomb. He's placed on term of probation not to exceed 60 months. He's ordered to pay fines and cost of $1,028. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. Within the next 30 days, he must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substances not prescribed by a treating physician. He'll be subject to random UAs at his own expense. Also, within the next 30 days, he must undergo a mental health evaluation and follow any recommended counseling. If he's required to give a DNA sample, he must submit one if forfeit any seized items. Mr. Whitaker, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. You step over, be fingerprinted, and speak to the probation officer.
Yes, sir, and I apologize. Thank you.
Yes, sir.
Carolyn Shaw found. Your Honor, this is Carolyn Shaw found, case number 26-174. Have you already filed some information?
Yes.
We'll waive a formal reading of the information, enter a plea of not guilty, and ask for a pretrial date.
No, I'd like to state this, Your Honor.
You need to check with Ms. McCarthy
You
Mm-hmm.
first.
can't do that today,
Why?
because,
I've already been held 60 days and I didn't do this. And there was no evidence, there was no lab work, there was no investigation. You've never even mentioned, you've never even contacted me in jail and you. No, I got the paperwork here. You have not.
I apologize.
You apologize and I'm getting my disability check stolen from me being in jail.
All right, I'm going to set an, what do you want to set, April 23rd?
Yes, sir.
April 23rd at 9 o'clock.
Thank you. Jessica Hall. Your Honor, this is Jessica Hall, case number 24-2333. In Ms. Hall's case, her case is two and a half years old. It's her co-defendant has already pled to it. It was putting a telephone into a machine. So we're asking to reduce the bond if we could. It's 25,000 right now.
Hold on just a second.
Yes, Your Honor.
Yes, sir.
There's an outstanding warrant in this case for 2 years. The defendant was not picked up until recently. Although in a standard case, a lower bond might have been fair. given the significant, given the proven history of being a flight risk and the fact that it took 2 years to be able to serve this warrant, the state would object to any modification of bond.
Well, I'm going to deny the award tennis bond at this time if you want to file a motion, but,
Yes, sir.
and we'll set it
Okay,
for,
we'll waive the formal reading, enter a plea of not guilty, and ask for a pretrial date.
all right, April 23rd. at
Yes,
9
sir.
o'clock.
Is not
Thank
gonna read my
you.
bond?
No.
Can I speak?
No, ma'am.
Oh, okay.
Wells.
I better take her back before she gets, before I do modify the bond.
Your Honor, this is Tara Wells. She's here before you in case 26303, and information's been filed in her plea of not guilty, demand for discovery, trial by jury. She also has a BOP case 25411, 251789. Will enter a denial. If we could pass her, what do you think, a month? You'd be ready in a month?
Yeah, Your Honor, what's going on in this case is that she has 2 misdemeanors that are going to be transferred to circuit court. Then she'll be arraigned on that, and then we'll be able to set it for an evidentiary day.
Okay, so you want to set it for an arraignment in April, or you want to set it for a VOP in April?
Probably better to set it for another arraignment date, Your Honor.
We'll set it for April 20th at 9 o'clock for an arraignment, anticipated new charges, then we'll set an evidentiary hearing after that day if there's not a resolution.
All right, I'll come back here and see you. You're just going to come back.
Good, you ready?
Yes, sir. Shannon Coley. The state has filed an information in this case. We'll waive a formal reading, enter a plea of not guilty. She has a new case on the April 20th docket. If we can just go to that date, the state has made a 3-year prison offer. She's rejecting that.
I will set everything for April 20th at 9 o'clock, and we'll place those. What's the other charge, Ben?
Battery on inmate. We set a VOP evidentiary on the VOP stuff.
Yeah, let's set it for, let's set everything for April. Can we do it in April? Jillian?
Yes, Your Honor.
Let's set it for April 22nd at 9 o'clock for the arraignment and pretrial on the new charge, and also a preliminary on the VOP, and at 1:30 for an evidentiary hearing on the VOP.
We'll be in touch.
Yeah, we'll move the arraignment to the, yes, ma'am.
Pablo Riviera out. Come on up. Come on, this way. Just right here. Yep. I don't know if there's information in this case yet, Your Honor. Okay, we'll waive a formal reading, enter a plea of not guilty. He comes back on Friday for a bond reduction hearing.
I'm sorry, who is this again?
This is Pablo Rivadeneira. Rivadeneira.
Okay. All right, we'll see him, Friday morning.
All right, we'll see you Friday, okay?
Your Honor, I have John Sullivan. He's here before you in case 26603, and information's been filed in her plea of not guilty demand for discovery trial by jury. I do believe that we may be on your bond docket for Friday.
What's his name?
Sullivan?
Yes, we'll see him Friday morning at 9 o'clock.
Yes, sir.
So I'll see you Friday.
Okay, friends, let's go back up to Michigan for another round with Judge Elmore.
Also before the court this morning is Mr. Kevin Stepleton. He's the agent in the Department of Corrections. He prepared today's pre-sentence investigation report. We're here today for sentencing after a no contest plea was accepted back on February 6th of this year to an attempted felonious assault or assault with a dangerous weapon. Before I'll turn to that, I'll note that the court has received some statements and certifications noted here. For instance, there's one from a program called Peak Performance Training Centers dealing with coping strategies, managing stressors, maintaining stability in a daily functioning, and so forth. I've read through that. There was a certificate that came from Meridian Residential Treatment Program. Also, a statement from a peer recovery coach. And that as well. Take a look here. Mr. Carnes, did you have any amendments, corrections, or objections to make to the contents of the report?
No, Your Honor.
How about you, Mr. Mankiewicz?
Your Honor, I've been over the pre-sentence information report with my client, and neither one of us have any additions, corrections, or deletions.
Thank you. One of the few times where somebody filled in almost all of the language. Appreciate that. Talks about medication, medical health, things like that. I really appreciated that. That tells me that it's not made up. All right, allocution or any victim impact statement, Mr. Carnes?
Again, we have Mrs. Frick to read the victim impact. Oh, I'm sorry.
Oh.
That's right. It's Natasha Roll from Oasis.
Thank you very much, man. All right. You may proceed. And it's a written statement from whom?
3 victims.
Yep, okay, go ahead.
Your Honor, my name is Angela Kirchner. I am one of the victims in the case. I am also the mother of 2 children, Madeline and Douglas, who are also victims during the unit. The events of the day have had a profound and lasting impact on me and my children. The fear we experienced was very real and very overwhelming. The sound of the trigger being pulled while the gun was pointed at my head is something I will never forget. The emotional impact of believing that I was about to be killed by someone who was supposed to protect and care for me is something that has and will stay with me for a long time. Since that day, my children and I have been working through the trauma and therapy. The incident did not occur in isolation. It came after a long history of mental and emotional abuse that was created an environment of fear, manipulation, and control within our family. Over time, this behavior has affected our sense of safety, trust, and well-being. We have been working in therapy to understand and heal from the psychological harm and resulted from Mitchell's pattern of behavior. Since the incident, we have also felt uncomfortable and uneasy by his attempts to contact with extended family members and friends on social media. Requests feel intrusive and concerning to us, given the long history of manipulation and emotional abuse from him, as well as circumstances in this case. It makes us feel as though our boundaries are not being respected and adds to our anxiety about our safety and privacy. This experience has left us with anxiety, fear, and deep sense of vulnerability. As their mother, it is extremely difficult to watch Madeline and Douglas have had to go through in dealing with this incident. My children have to cope with trauma that not a child, regardless of age, should ever have to experience, especially from their own father. For our safety and our continued healing, it is extremely important that the no contact order remain in place until we feel ready and safe. Right now, contact would only reopen wounds and disrupt the progress that we are trying to make in therapy. We need time and distance in order to recover and rebuild our sense of security. What makes this situation especially difficult is seeing the attempts to shift blame or minimize what happened. For the three of us that were affected, the fear and the trauma were real, and the impact to our lives continues every day. The emotional damage of the experience does not disappear simply because the gun was empty. My hope in sharing this statement is that the court understands the seriousness of what we experienced and the lasting impact that has had on me and my children's lives. This was not a moment of poor judgment. It was an act of caused profound psychological trauma to the entire family. We ask the court to consider the safety of my family and the long-term impact of the crime when determining sentencing. We need time, distance, and continued protection that the no contact order will provide us in order to heal. Thank you for allowing me to share how this has affected me and my children. The next one is, Your Honor, my name is Douglas Kirchner. I am 14 years old. I was 13 years old when my dad pointed a gun at my mom's head and at me and my sister, and then pulled the trigger. When he pointed the gun at me and my sister and pulled the trigger, I thought I was going to die. I did not know the gun was unloaded. I was very, very scared. And I still think about it every day. Since that night, I have felt different. I felt anxiety. Since then, he has been out of jail. I feel less safe than I used to. It has been hard for our family, and I'm going to a therapist to talk about my fears and anxiety. My dad was supposed to protect me, but that changed how I feel about being safe and trusting people. Right now, I feel like it's important that for the no contact order to stay in place so that I can feel safe and focus on healing. I don't want to have any contact with him right now. I'm asking the court to consider how frightening that moment was for me and how it still affects me today. Your Honor, my name is Madeline Kirchner. I am one of the victims in this case. I am writing strongly and urgently request that current no contact order involving Mitchell Douglas Kirchner remains in full effect. This order was put in place for a reason and has helped me feel even the slightest level of basic security. The day this happened, it was something I will never forget. When my father pointed a gun at my head and pulled the trigger, I truly believed I was about to be a victim of murder. In that moment, I felt fear and shock that are very difficult for a brain to process or even describe. No child or adult should ever have to face something like that, especially from their own parent. Even though the gun was later found to be unloaded, I did not know that at the time. I believed my life was ending. That moment has stayed with me and continues to affect me emotionally. This was not a minor or misunderstood situation. It was a life-threatening act that demonstrated as a complete disregard or forfeiture of my well-being. Since this incident, I have been dealing with anxiety and emotional trauma. Our family has been working through these experiences in therapy. I hope the court understands that they are dealing with a man that does not feel remorseful for his actions and will push our boundaries. I do not believe my safety would be respected without continued legal protection. My life may be in danger if the no contact order is removed due to the previous threats on my life from Mitchell. For my own well-being and safety, I believe that it is important, and I beg the court that the no contact order remain in place for the sake of my fiance, my future son, and I. Right now, the distance is absolutely pertinent so that I can continue to heal. I hope the court understands that what happened that day has changed how I feel about safety and trust. And I ask that my family and my family's safety and healing be taken into consideration is decided. Due to Mitchell's lack of acceptance responsibility for his actions, I ask on top of the no contact order that you give him the maximum possible punishment for his crime against me, my brother, and my mother. Thank you for allowing me to share how this has affected me and the people I love. To Mitchell, I hope this day has been a wake-up call for you regarding your poor choices and actions in life. What would your father say about the things you have done to us? Just food for thought. Romans 12:19. Beloved, never avenge yourselves, but leave to the wrath of God, for it is written, vengeance is mine, I will repay. says the Lord.
All right. So we're going to reopen an issue. And contained inside the PSI on CFJ 284, page 3, I knew that there wasn't any victim impact statement to be attached and that it was to be read. Now, I don't know if anybody understands why I'm now talking instead of talking before, but it's now because I have information that establishes by a preponderance of the evidence issue for the offense variables. So let's take a look here at offense. Now they may or may not be, it may or may not change, because I already understand that his PRV, I'm sorry, his OB level is already maxed out, because for a class H offense, it's maxes out at 61 points and he's at 55. Why was no OV4 scored? That sounds like serious psychological injury requiring professional treatment. Court adds 10 points for offense variable 4. Now, this one raises an interesting question. First of all, I don't know why all OB5 did not appear in the offense variable scoring. It makes me wonder if the Department of Corrections, if the program's changed, because OB5 is listed under crimes against a person. You'll note Mr. Stapleton and OB5 doesn't even appear on the guideline scoring, which makes me wonder if there's something wrong with the program.
Very well could be. And
yeah, that OV5 is missing, because OV5 would be psychological injury to members of a victim's family, and clearly there could be some there. But maybe I'm going to take a look, and I'll invite counsel to make an objection here, or any objections again. But I don't know why OV7 wasn't scored. Because what I've just heard, in addition to what I've read inside the PSI, the victim was treated with sadism, torture, excessive brutality, or similar egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. So, one offense, assault with a dangerous weapon, could just be pointing the gun or waving the gun, putting it to a head and pulling the trigger to go click. To me, is egregious conduct designed to substantially increase the fear and anxiety in the victim. All right, so let's take a look at offense variable number 4. Mr. Carnes, any argument as to my position and interpretation of OV4?
Your Honor, I agree OV4 is properly scored at 10 points.
There should be one in your drawer there, just to make it.
Sorry,
that's okay. Next, there should be books inside your drawer too.
Okay.
I normally put copies in them. Go ahead.
OV4,
Yeah. That's 10 points. Because we took at one of the stories there included that they were getting counseling. And obviously that's why we have Oasis here today.
I acknowledge that the computer program may be wrong, but that is properly scored.
Well, that's OV4. OV5 is something different. So that one is serious psychological injury requiring professional treatment to a victim's family.
And that is only scored in homicide cases. Your Honor.
Yep, I know. So we don't cover that. And so that's why I mentioned maybe it wasn't in the program because of that there may have been a mix up in the programming, but maybe it didn't apply. All right, so we've got to add 10 points here for OV4. And then the next point here is OV7. OV7 is for that brutality. It's the court's position that OV7 should read 50 points because of the click. The fact that the person thought that their life was over. Now, in the end,
without further researching that particular issue, the only thing I could add is, without minimizing what happened here, of course, is that this wasn't a point blank situation. It was in the same room, but a different part of the room. But again, without having a chance to research that particular point.
Excellent. So the court's going to add 50 points for that offense variable. All right, thank you. Allocution, Mr. Minkwitz. Oh, wait, Mr. Carson, sorry.
Thank you, Your Honor.
By the way, that increases the total OV to 115 points. Thank you. You may continue.
Your Honor, the victim impact statements highlight how terrifying this was to the victims in the moment, and I'd ask the court to take that into consideration. I do ask the court to sentence the defendant to 36 months probation with a no contact order to continue. And I believe that this version of attempted assault with a dangerous weapon does qualify as a domestic violence crime. Therefore, he would not be eligible for early release from that probation. Thank you.
One moment, Mr. Minkwitz. All right, Mr. Minkwitz.
Thank you, Your Honor. Again, just like I said, certainly not to diminish the seriousness of this situation at all. And Mr. Kirchner seriously certainly takes responsibility for this. This is not a killable plea. What happens here is up to the court, and he's fully aware of that. Your Honor, but it's important to see how we got here today and how this Mitchell Kirchner sitting before you today is not the same one that we saw back then. Starting off earlier in life, Mitchell was in the Army, suffered a bad Army back injury, and immediately got on the prescription drug train through a doctor. Fentanyl patches, roxycodone, I didn't know that was even a thing. It's even more serious than
more than regular.
Yeah.
Yep.
So, yeah, this is all through a doctor, Your Honor. He's never bought drugs off the street. He's had different enablers throughout his life, unfortunately, including a doctor, but the pill still went from his hand to his mouth, Your Honor. But since this event took place, when he came to me, he had already been to Meridian, inpatient treatment. He has a counselor. He has ongoing treatment. He's in AA with a sponsor. He has a job doing very, very well. Not in this area, but down in the Grand Blanc area. He's making strides upon strides upon strides. Unfortunately, Your Honor sees it's going to result in some serious trauma to his family and his marriage. But Your Honor, when he was initially arrested, he spent 52 days in intake, detoxing. The worst 52 days of his life.
I can imagine.
And he learned an important lesson about this, and that set him on a different path in life, Your Honor. But again, I've submitted a couple letters and a certification showing that he's taking this very seriously. And I will just end by pointing to page 6. Mr. Stevelton really hit it on the head, I think. When you look at the substance abuse narrative and you move into what he's done since in recovery. Yeah, he goes from taking Valium, fentanyl patch, roxycodone, enough that my understanding is that when he was being evaluated by doctors in this matter, if he would have stayed on this path, he would have been killed. Again, he takes full responsibility for having that unloaded gun in his hand in that living room with his family and pulling the trigger. He did it to himself as well in the living room. He is beyond himself. He comes, most of the time I talk to him, he's crying because his kids won't talk to him anymore because of this, Your Honor. He is, continues to work through counseling and is deeply sorry and takes responsibility for this horrible night and what led up to it, but he's happy about the changes he's made, Your Honor.
All right, Mr. Kirchner, you have the right to make a statement if you choose to do so, or is there anything you wish to say today, sir?
Your Honor, I'm probably going to speak very cautiously here because my words can't be taken back.
Well, and hold on, I do acknowledge that there was a no contest plea.
There's no contest, please. So if you want to stay away from what happened and just talk a little bit briefly about how you're doing.
I trusted Mr. Mankiewicz to talk to you about that as he just did now. You may go ahead, sir.
Yes, Your Honor. Brief. My wife and children and I moved up to Cadillac. On our way, about 80 acres on a farm. Secluded with my family. I had stored his firearms at his camp at my house. The whole situation was very strange. And I think if anybody else's partner saw them struggling like that, that they would probably video the guy and courthouse. And since this has happened, I still can't sleep hardly from the 52 days. I tremble. The day that I basically got out, I was very confused, just got out of place. But since then, as a soldier, I have basically marched forward in every single facet of life, head on. I haven't wavered, and I cannot think of anything that I could do to better myself more. I've lost 66 pounds and changed everything. And I have not.
Take your time. If you need to stop and turn to Mr. Mankiewicz, that's absolutely appropriate.
Yes, Your Honor, I do. I think you can see by my shaking that I take this very seriously, and I know very strongly everything that happened and what has happened since then. But I can't, not even for my personal well-being right now, I can't think of anything else I could have done at this point to better myself. And it doesn't, the court did help me push to do that, but I did not do this for you or anybody else. I did this because it was the right thing. And I do absolutely take responsibility. And it's a very sad deal.
Thank you, sir. All right, so I'll start with the last thing said. I acknowledge and appreciate how difficult it is for a defendant with a no contest plea to make these statements, how difficult it is. Even just, I don't want to say the word in a bad way, but tactically based upon law, legal advice, and how whatever he says could be used against him. I don't hold that against him. I recognize that he's got counsel, so I clearly don't take anything negative from that. There's a reason why the law allows a no contest plea, and therefore, again, I take that under consideration with a little bit of salt or sugar, or however the appropriate wording. Well, how long were you in the service? And I don't remember who talked about this. You were in the National Guard, is that right? And always wish this basic information report with CFJ 101 would tell me what an MOS he had. What was your MOS? Infantry? Okay. All right, yep. The fact that the defendant was in prior service, most people know that I served for 4 years and retired as a lieutenant colonel. And it's interesting to me because there's a part of it where you give credit to somebody for their service, you appreciate their service. And on the other hand, this kind of goes back and forth across the net. Then on the other hand, that's what soldiers are supposed to do. They're supposed to pull themselves up by the bootstraps, put their ruck back on, pick up their firearm and keep marching forward. And so therefore you expect that a lot more to be expected of that soldier. Then on the other hand, it's that mentality that drives probably what we got here, and that is driving forward, lots of pain, dealing with it probably reticently, and taking the medications as prescribed, given to you by a doctor. So it kind of goes both ways. And so it's always interesting to me how to apply prior service. But it helps me lend a little bit more understanding about the defendant and a bit of his mindset and personality. While I was not an 11 Bravo, I did some military stuff, jumping out of planes and things like that. So I get an idea, spent a lot of time even deployed working with people who are 11 Bravos. So I understand. At the same time, I look here and say we've got a defendant who is seriously struggling with some addiction issues. And as I say almost every Monday and often on Fridays, anybody who thinks that drugs are a victimless crime are fooling themselves. Come spend a Monday morning here in this courtroom and I'll prove to you that they are not victimless crimes. And drug addiction, drug use has a significant impact on individuals and their families and their communities.
Were you trying to make say one last three?
It's okay. Go ahead, Mr. Mekwitz. It's okay, but ask Mr. Mekwitz what it is, because I don't want you to just. Anything?
Well, disregard, Your Honor.
It's okay.
Mostly right.
Thank you. All right. So again, let me keep going here. This is an intermediate sanction cell. There is an intermediate sanction cell statute that talks about how there is a presumption of probation and fines and over confinement. However, that same statute does give the court a couple different ways to look at it. Number one, the court can take a look at the factors and look at the facts and say, well, the guidelines are insufficient. And also the statute allows that presumption to not apply in a serious misdemeanor. And in this instance, the court finds that the count is a serious misdemeanor.
Yep. The 2-year felony.
I'm sorry, but it's a felony, but it's similar. It's a similar process. Yeah, it is. I got it. So, but anyways, but also it involves, there's an acceptance as to domestic violence. And so there's a lot of, my point is there are several exceptions underneath that definition that would apply here. And the guidelines well exceed, I mean, the offense variable maxes out at 16 points. And we're up to 115 points. And therefore, again, the guidelines really do not adequately cover it. Now, the parties have reached a plea. It somewhat ties the max that court's hands. I mean, we were looking at 5-year offenses, but now we're at something less than that. Technically, an attempt. Again, a few judges are working on trying to get this language changed because it's a bit confusing. Is technically, while it does say the statutory max is up to 24 months, and that's what it says on the scoring, it's actually not correct. It's actually still equal to 5 years or 1 year in county jail. That's actually how the max should read, but I'm going to trust that your program is probably messed up for the same reason people misunderstand the statute for attempted convictions. If it were less than 5 years, if the original offense was less than 5 years, then it would be considered a misdemeanor and it would be punishable by up to half that period of time. Yes, sir. Am I right?
The original offense is a 4-year.
4 year? Okay.
Yes.
I thought we had a 5-year for it.
No.
No.
Bologna itself is a-
No, but I'm sorry. I thought I looked earlier at a 5-year. Well, thank you, but still, it does include a potential of prison. So here we go. Also, the factors here. This was a terrifying event for these children, these family members. One of them, 13 years of age at the time. So the court places the defendant on a period of probation for 24 months, which is consistent with the recommendation. The court adopts the terms or conditions largely that are listed on CFJ 145 pages 2 and 3, unless this other, except for where the court will otherwise differ. The court assesses a $68 state minimum fee, $130 crime victim right fund fee, a $300 court cost. Mr. Mankiewicz, you're retained, am I correct?
Yes, Your Honor.
You didn't take it as an overflow. So therefore, there's no attorney fee. Court assesses a $500 fine. I assume DNA was taken here?
Yes, Your Honor, $60 to the Wexford County Sheriff's Office.
All right, the court will add that. Supervision fees of $30 a month or $60 a month if there's any electronic monitoring. Now, of course, if everyone's paying attention, the court is now at a position or at the stage where they assess jail. 1 second. Again, the maximum punishment here is up to 24 months, and thank you all for the correction. That's everybody makes an error, and I was in error. For some reason, I thought we had a 5-year offense originally. But anyways, it's a 2 years in prison or 1 year in jail and $1,000, not to exceed half of the original amount. I'm not going to exceed that half, obviously, and I'm not going to give a prison term, but the court is going to give an additional jail term, and the court sentences the defendant to 300 days in jail with 50 days of credit. I find that sentence is reasonable. Again, the guidelines, while it's a intermediate sanction, the law allows the court to override the presumption. Furthermore, the court finds that based upon the facts and circumstances of this case, it's quite egregious and quite scary, and people were put in fear of their lives that it was going to end. Therefore, again, I find that the sentence is fair, reasonable, and proportionate upon all those factors. All right, have I missed anything, Mr. Stephan?
I know you're on.
Mr. Carnes? All right, Mr. Mankiewicz is going to bring to you, Mr. Kirschner, 2 copies of one document. You're going to place your name, your initials on the first one. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of the document, which is the other copy. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. Based upon the plea, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you, then you may return it, but it must be done so within 42 days. Mr. Kirchner. To anyone who serves, a lot is entrusted and a lot is expected, and the same to a father and a husband. We all fail, though, in those meeting those goals sometimes. But the challenge for you is to accept it, acknowledge it, put that rucksack back on, and when you get out, march in the right direction. I have no doubt that you can do it based upon the factors that I've talked about. That's the substance of the goal. Again, while I note that it exceeds the guidelines, which were 0 to 6 months, again, I've already stated, I think the guidelines are. Thank you. Thank you. All right, our next file this morning is.
Okay. I'm kind of glad that it's time to end the day because, to be honest with you, I can't recall the last time I've walked away from a hearing this frustrated, and I normally don't close out my show angry, but I'm angry. I don't see this one. So 100 days in jail, credit 50, and 2 years probation for putting a gun to the head of a family member and pulling the trigger, loaded or unloaded. He put a gun to the head of a family member and pulled the effing trigger. So I'm angry. But I did enjoy my day with you. So thank you for that. We will be back tonight over at In the Blind, Michael Groff and I, 7 p.m. Eastern, 4 p.m. Pacific. Please do join us there. It will be a lot of fun. That is a good show that just needs to get found. I think we're on, episode 13 or something like that tonight. So do check us out over there, youtube.com/@in-the-blind. I'm sure Barbara can drop a link. But join us over there, and we'll be back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Go have yourselves a good Monday, or as good as your Monday can be. I'm going to go get myself a nice juice or something and get rid of my anger and get on with my day. But again, it was good being with all of you, so thank you so much. Take care. God bless.